Good morning, everybody, and welcome to the August 22nd, 2024 meeting of the Arizona State Board of Pharmacy. My name is Lori Walmsley, and I'll call the meeting to order. Dr. Gandhi, if you could do conflicts and roll call, please.
Thank you, Madam Chair. Mr. Braswell.
Here, no conflicts.
Thorwald.
Here, no conflict.
Ms. Nair.
Here, no new conflicts.
Ms. Davis.
Here, no new conflicts.
Ms. Walmsley.
Present, no new conflicts.
Ms. Lehan.
Present, I added 27C, case number 23-0199 today.
Thank you. Mr. Dang.
Present, no new conflict.
Mr. Al-Nassif.
Here, no new conflict.
And Mr. Anderson.
Here, no new conflicts.
All accounted for, Madam Chair. Just a quick note, though, if you can, the folks in the back of the room are having a hard time hearing us, so if we can maybe move up to the mic or move the mic closer to us, that would be appreciated. Thank you.
Thank you. I know we have a couple new people in attendance today that were not in the audience yesterday. The board does offer continuing education for attendance at the meetings. If you're interested in continuing education, please make sure that you sign in the back. You can get CE credits for this morning and for this afternoon. If you want to receive a full day's worth of CE, you do need to sign in twice. So just making sure everybody knows that that's an option for you. We're going to go ahead and move to our hearings, tab 26. I am going to pull item 26B for Sophia Renee Grant, as I'm already recused from that matter. Mr. Hargraves, are there any other matters that we have preliminary pieces that we need to address, or can we take the other three together?
We can take the other three. There's nothing preliminary.
Okay. This is the time for the board to consider consent agenda items consent agenda items 26A, 26C, and 26D. Spencer M. Villanueva, board case number 24-0165. Jose Delegado Castro, board case number 23-0059. Cameron Taylor Smith, board case number 23-0139. Does any respondent, attorney, or board member wish to pull any additional cases from the consent agenda for further consideration? Hearing none, will the state's attorney please introduce themselves?
Yes, good morning. Seth Hargraves, Assistant Attorney General on behalf of the state.
Are there any other parties present? Mr. Villanueva, Mr. Delegado Castro, or Ms. Smith?
Not that I'm aware of.
Okay. The state has filed a motion to deem and to vacate the hearings in each of these matters. If these motions are granted, the board will have adopted the factual allegations set forth in the complaints as the findings of fact and the alleged violations of law as its conclusions of law. Is there a motion with regards to the state's motion to deem?
I move the board grant the state's motion to deem and vacate the hearing.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. We'll now deliberate on the appropriate discipline to be imposed. Mr. Hargraves, do you want to address that at all?
Yes, thank you. In each of these cases, the complaint notice of hearing was sent to the address of record as well as to the email address of each party. There was no response. The state filed a motion to deem. There was no response to that based upon the failure to communicate with the board. The state would recommend revocation in all three cases. Thank you.
Thank you, Mr. Hargraves. Board members, any discussions, or do we have a motion with regards to the discipline?
I move to adopt the state's recommended discipline as set forth in its motion to deem and vacate the scheduled hearings.
Second.
I have a motion and a second. Any discussion? Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Braswell.
Aye.
Mr. Thorwald.
Aye.
Ms. Nair.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. This concludes these proceedings. The board's decisions will be reduced to written orders, which will be sent to each of the respondents. Dr. Anderson, I'll give it over to you for 26B.
Thank you, Ms. Walmsley. This is the date, time, and place where the matter dealing with Sophia Renee Grant, board case 24-0152 is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. The board is committed to ensuring that its business is conducted in a respectful manner. When conducting formal administrative hearings, the parties are expected to treat the board, witnesses, and each other with respect and in a civil and courteous manner. The parties shall not engage in any conduct that brings disorder or disruption to the proceeding. Neither party will be allowed to interrupt the board or the opposing party except where necessary to make an effective objection. If a party does not adhere to these basic civilities, the board will ask the party to modify their behavior. If the party continues to exhibit disruptive behavior, the party's microphone will be muted until it is their turn to speak. Board members today include Jeff Anderson, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Tennille Davis, Tarek El Nassif, and Les Braswell. Let the record reflect that the board members have been furnished copies of the complaint, notice of hearing, and all pleadings of record. Will all parties please introduce themselves?
Which particular case are you referring to? The
Sophia
Sophia Grant,
Sophia Renee Grant,
Okay.
24-0152.
Seth Hargraves, Assistant Attorney General on behalf of the state.
Yes, please do.
My name is Sophia Renee Grant.
Thank you, Ms. Grant. Do you have an attorney? Okay, you have the right to be represented by an attorney, but the law does not provide for an appointment of counsel on your behalf. If you want an attorney, it is your responsibility to secure and pay for one. By proceeding without representation of legal counsel, you are waiving that right. This hearing is your opportunity to present testimony and evidence on your behalf. And if you appeal the board's decision, the record you make at this hearing today will be evidence considered by a court in determining whether the board's decision was proper. Do you understand what I've told you? And do you wish to proceed without counsel today?
I do.
Dr. Anderson, this is state filed a motion to deem.
I guess I need a motion for legal advice then.
Go into executive session for legal advice.
Yes, please.
A board member could make that motion.
Motion to go in executive session for legal advice.
All in favor?
Aye.
Any opposed?
Hello. Okay, 527-034.
All right, are we back live streaming? All right.
Hello.
All right, we'll go ahead and proceed. Mr. Hargraves, are you willing to consider withdrawing the state's motion to deem?
I'd like to address the board as far as the motion, if I may.
Absolutely.
So this case initially started with board case 22-0741. After the investigation of that matter, this board issued a non-disciplinary order for a civil penalty in the amount of $500 that was issued October 25th, 2023, requiring a payment by February 28th, 2024. In March of 2024, when that civil penalty was not paid, the board opened a new complaint. Notice was sent to Ms. Grant about the new complaint. She responded to that, asked for an extension to pay the penalty. An extension was given until May 15th. May 15th came and went. She failed to pay the civil penalty. And at your last meeting in June, this board voted the matter to hearing. June 21st, complaint notice of hearing was issued, notifying Ms. Grant of today's hearing date, notifying her of her obligation to file an answer to the complaint, and notifying her if she failed to do so, the matter could be deemed admitted. She failed to respond to the complaint notice of hearing, and a motion to deem was filed. All along the way, all documentation was sent to Ms. Grant at her address of record, as well as her email address on file. There were responses to some things, not to others. In this case, after the motion to deem was filed, she did respond, indicating reason for her failure to respond. However, again, everything's been sent to the addresses of record, and there is evidence that she has been receiving them. Thus, the state would ask the board to deem the allegations admitted. However, because there is a response now, we would ask the state would rescind its request for revocation. In light of the issues, perhaps the board could consider a different outcome, including maybe a decree of censure, disciplinary matter for violating the board order. If the board denies the motion to deem, we'd ask that the matter be rescheduled for hearing at a future date.
And Ms. Grant, what is your position on the state's request to their motion to deem?
When you say deem, you mean take away my license?
Would you like to explain for?
That could be a consequence of the state's motion. However, you just heard from the state, and they are asking the board that if they do consider granting the motion to deem, that they revisit the disciplinary portion of the motion.
I do take full responsibility for what brought us here. I've been just going through some things personally the case in question, why I was being penalized. I was just going through my probation, having to pay those fees so that when time came, I can walk away with that and be on a clear slate. So my housing situation hasn't been okay. So it's not like I've ignored what I need to do. I just haven't had the means to do it. And I did explain that in my answer back to him. So the address on file is basically right now my mailing address. I do have someone that lives there that can get me the mail, but I'm not always able to get to it. I just got a new phone as far as like emails, receiving those. So I would appreciate if you would just give me a little bit more time to pay that fine. I'll get it done. I don't want to lose my license. I worked very hard for that. So that's my stand on it.
Thank you, Ms. Grant. Any discussions with the board?
Just what our options are. Are we able to continue or reschedule or?
Well, I think the first thing the board should consider is whether or not to grant the state's motion to deem. And if you do, then you can consider what final action to take, whether that's revocation or something less than revocation as the state, introduced this morning. But the first question is whether or not to grant the state's motion to deem. If you deny it, then we can talk about next steps.
I move we deny the state's motion to deem.
Okay, we have a motion to deny the state's motion to deem. Do we have a second?
Second.
Do we need roll call, Dr. Gunning?
Any discussion?
Any discussion? All right, all in favor, please say aye.
Aye.
Any opposed? All right, motion carries.
Mr. Vice President, members of the board, the state asked that if you did deny the motion to deem, that you consider continuing the matter so that both parties can properly prepare for the administrative hearing. So I would ask that that be your next consideration.
So I make a motion to continue the matter.
Second.
Did you, before voting on it, did you want to hear from the parties one more time? Just on that question.
Mr. Hargraves, would you like to share any additional comments?
I have nothing further.
Ms. Grant, any additional comments?
When you say, explain the continuation for me, please.
You're going to continue in your current sham probation?
I'm sorry, is that okay? So the state issued a complaint, and because you didn't timely answer, they filed a motion to deem the allegations admitted. The board just denied that, so we
Okay.
still have to address the underlying complaint that was issued.
Okay,
That complaint indicated that there was going to be an administrative hearing this morning.
okay,
However, given the situation, the board is considering continuing the administrative hearing to probably their next board meeting. At which time you will need to be present
okay,
and to present whatever evidence and information that you have that addresses the allegations in the complaint notice of hearing. You do have a copy of that document?
I do.
Okay.
Okay.
I hope that answered your question.
Yeah, that's fine.
Do you have any other?
No.
All right, so we have a motion and a second on the floor. Any additional discussion?
No, I think, Mr. Anderson, I think you were asking whether her license was suspended or it's still open status right now.
All right, we'll move for a vote. All in favor, please say aye.
Aye.
Any opposed? All right, motion carries. The hearing will be continued until our October meeting.
And Miss Grant,
Yes.
you will receive notice of that, but can you make sure that you provide the board with your current contact information, the best way to reach you?
So everything is still the same. It's just as far as mail goes, I might get it a little bit delayed, but you can still send mail to the same address. But I do have a question. If I'm able to pay this fine by the time this hearing comes back around, would that suffice the board or?
I can't answer that question. What I would ask you to do is reach out to Mr. Hargraves.
Mhm. This gentleman?
Yes,
Okay, all right, no problem.
thank you.
Thank you, Ms. Grant. That concludes this matter.
Thank you.
Welcome back, Ms. Walmsley.
Really take it back. All right, we'll move to tab 27, 27A. This is the date, time, and place where the matter dealing with South Central Pharmacy Board Case number 23-0155 is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Jeff Anderson, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Tennille Davis, Tariq Al-Nassif, and Les Braswell. Let the records reflect that the board members have been furnished copies of the complaint and notice of hearings and all pleadings of records. Will the parties please introduce yourselves?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Good morning, Courtney Sullivan with Boson and Snow on behalf of South Central Pharmacy and Ms. Omodara.
Olufemi Amadara.
Welcome, thank you. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In disciplinary proceedings, the state bears the burden of proof and shall present its case first. Mr. Hargraves, would you like to make an opening statement?
Madam President, if I may, at this point, we have recently been retained. We don't have the evidence against my client, and we would be asking that this matter be continued to the October agenda.
Mr. Hargraves?
Madam Chair, this matter has been going on for quite some time. It started with a failed inspection back in 2023, and then a re-inspection, and then issues with that. When the board reviewed the results of the re-inspection, there was a representation that the pharmacy would be closing on May 3rd. Because of that, the board set aside its issues with the issues in the re-inspection and decided to dismiss the matter upon documentation of the closing of the pharmacy by May 3rd. After that, the reimbursement of costs was not timely paid and the pharmacy did not close. The decision was made to not close it despite their representations to the board. In June, this board voted to send the matter to hearing. A notice of hearing was sent out June 26th. A response to the complaint was received the very next day. Exhibits were sent, basically the record in this matter, to the owner on July 23rd. And then there was nothing further until last Friday. There's been plenty of opportunity to obtain counsel prior to this last minute and the delay. Now, understandable, the issue here is with the permit. As such, the individual owner cannot represent the permit before this board without counsel. Thus, continuance may be appropriate. However, when the board voted this matter to hearing, what you voted it on was violations of the re-inspection order. The violations found, the misrepresentation about them closing the pharmacy on May 3rd, as well as the failure to timely pay the inspection costs. If the board is going to grant the continuance, the state would ask that the additional issues be added to this matter. Again, the reinspection did have violations. We would ask that those be added to this matter to be considered. Specifically ARS 36-2523, Arizona Administrative Code R4-23-611A9 and B3A, as was stated in the results from the inspection. Add potential violations of 32-1901.01A 2, 5, 6, and 15, which would be added to the 14 and 16 that are also laid out. And we would also ask that, I apologize if get the name wrong.
Ms. Omadara?
Yes, that she be added as a party as well. She is both the owner and the PIC. She was the one that made the misrepresentation to the board about the pharmacy closing. And as PIC, she has responsibility for the violations found in the reinspection. So we would also ask that the amended notice of hearing include 32-1901.01 B 2, 10, 17, 18, and 19. Thank you.
Thank you. Mr. Harris, looking for guidance. We can deliberate on whether or not we want to allow the continuance. Okay. Board members discussion?
I don't remember, but what was the violations? Was it anything that of immediate danger to the public?
Well, there were violations on a reinspection, so.
What I meant was what were the, I don't remember what those violations were.
I don't have those in front of me. They were not part of what was noticed for today.
I would tell you, but I don't have them either because they haven't been provided to me by the state.
It's just about like
They were
inspection
provided to your
report.
client.
Yeah, just like about inspection report. It wasn't good. You know what I mean? And this is basically, it's not good for public safety. And she filled, yeah. Yeah,
According to the findings of fact in the original order, the inspections found improvements in facility sanitation, documents for the inclusion of the prescription order, improvements for immunization and compounding discussion were determined as the pharmacy had discontinued those services. 3 additional violations were issued for a lack of hot running water, excess expired drug products, and controlled substance record keeping. So there was multiple inspections with several violations, and some of the things were improved because they quit doing them, but we don't know because she didn't quit operating if she's still doing any of those things.
What's the status of the pharmacy currently? Is it open?
It is open. She's actively trying to sell the pharmacy, and that was her goal at the last in the May incident where she told the board that she was hoping to close. She was hoping to sell it. She had a buyer, and the buyer backed out, and she doesn't believe that she'll be able to sell it during the pendency of these matters.
I just think this keeps dragging on and on. I'm inclined, I kind of go back and forth because I agree to adding the additional information that Mr. Hargraves just cited. But I also think this just keeps getting kicked down the road further and further. It's been going on for quite some time.
I mean, I agree. It's been going on a long time. I do think that it would be fair for us to give them the opportunity to prepare. It is where my head is right now. They've been operating since before May.
Are we able to say this is the one and only time that we would do this? Because that's my thought, if we do allow it. Because
Or grant a one-time continuance.
I feel like we've been pretty deferential in understanding your circumstance, and we've given a chance and then another chance and keeps getting kicked down the road.
Exactly. And she's had plenty of time to retain counsel. I think this is plenty of time to retain counsel.
Well, I would hope that this board wouldn't hold her retaining counsel against her, but I would ask, yes, that we be allowed to continue this matter to October so that she can at least exercise her right to counsel and allow me to have a meaningful time to review the evidence against her prior to any hearing.
Madam Chair, I don't think it was the board's intent to hold it against her to get counsel. It was just the timeliness of it, right?
Exactly.
Getting counsel at the last minute before a hearing. I think that was a concern by the board.
She was noticed in June as per Mr. Hargrave's statement.
I'm personally fine with allowing the continuance.
I'll make a motion for a one-time continuance and the addition of the cited information that Mr. Hargraves gave today.
Mr. Harris, is that appropriate? Can we add that at this time? Okay,
I'll make a motion for a one-time continuance.
Second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none, motion carries. And with regards to the additional pieces,
Is to amend the complaint notice of hearing as recommended by the state. And I don't know if everybody followed what Mr. Hargraves presented to the board. I don't know if that needs to be repeated or if everybody understands what the state is requesting.
I understand.
does that everyone understand?
Yes.
I think that probably the biggest change is that Miss Omidar will also be included as a respondent. And then the additional findings.
I'll make a motion to amend the complaint notice of hearing to add the additional information that Mr. Hargraves presented.
Second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you for being present.
Thank you.
$27B, Joseph Michael Quintanar III. Yes, that was part of the motion to include her as well. Are we good to proceed? Okay. This is the date, time, and place where the matter dealing with Joseph Michael Quintanar III, board case number 24-0227, is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Jeff Anderson, Crispin Snare, Kevin Dang, Cedar Lahan, Frank Thorwald, Tennille Davis, Tariq Al-Nassif, and Les Braswell. Let the record reflect that the board members have been furnished copies of the complaint and notice of hearings and all pleadings of records. Will the parties please introduce yourself?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Mr. Quintanar, are you present? Hearing none. Mr. Hargraves, would you like to make an opening statement?
Yes, thank you. This case involves violation of a board order. On December 8th, 2023, this board issued Mr. Quintanar an order for non-disciplinary continuing education to resolve board case 23-0374. In that matter, there was an issue of continuing education deficiency on his renewal. The non-disciplinary order required him to complete 3 hours in error prevention. Well, I'm sorry, I don't believe that was a violation of CE. It was for a case, but he was required to complete 3 hours of continuing education in error prevention. The order CE was to be due on March 27th of 2024. On March 19th, Mr. Quintanar reached out to board staff asking for an extension. He was provided a 2-week extension. On April 8th, he emailed staff with the names of 2 courses that he indicated that he had completed. However, he provided no certificates for either course showing that they had been completed. Staff responded, letting him know that one of the courses was approved, the other one was not, as it didn't cover the appropriate material. On April 11th, a new complaint was opened for violation of the board order. He had previously indicated that he was having a hard time finding free CE to complete. In the new complaint was opened, this board voted the matter to hearing. Mr. Quintana responded asking that the CE he took be considered, even though it had previously been, one of them had been declined. At this point, Mr. Quintana has not technically complied with the requirements of the order by completing 3 hours of CE in error prevention.
Thank you, Mr. Hargraves. Board members, questions? Hearing none, do you have any witnesses, Mr. Hargraves, that you'd like to call?
Yes, the state calls Jennifer Mitchell.
Ms. Mitchell, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I just want to point out, Madam Chair, the complaint notice of hearing had 10 factual allegations. The state did file a notice of errata striking factual allegation 9. That is in your packet at page 4991.
Thank you, Mr. Hargraves.
Ms. Mitchell, could you tell us what your occupation is?
I am an executive assistant to the director for the Board of Pharmacy.
Are you familiar with the case involving Joseph Quintar?
Yes, I am.
And how are you familiar with it?
I was the investigator on the case.
Okay. And what issues did Mr. Quintana have?
He did not comply with an order for continuing education.
And is he currently licensed with the board?
He is.
If you can look at what's been marked as States Exhibit 1, it's page 2, Board Book page 4995, could you identify this document?
That's a verification of licensure for Mr. Quintana.
And according to this, what is the status of his license?
Open.
And when is it scheduled to expire?
October 31st, 2024.
Now, you said the issue has to do with non-compliance with a board order.
That's correct.
And looking at what's marked as Exhibit 2, beginning on page 5, Board Book 4998, can you identify this document?
That is an email from staff to Mr. Quintana notifying him of the board's decision to issue him a non-disciplinary order for continuing education.
And what is the date of this email?
December 8th, 2023.
Okay. And this indicates that their last meeting, the board voted to issue him that non-disciplinary order?
Correct.
And included with that email, was there a copy of that order?
Correct.
And is that order listed on, beginning on Bates page 6?
It is.
Looking at Bates page 7, what was the order?
The order required Mr. Quintana to complete 3 hours of continuing education in the in the area of error prevention.
Okay. And could you read after that further requirements regarding the CE?
The CE hours shall be in addition to and may not be included in the hours required for biennial renewal of respondent's pharmacy technician license. Respondent shall provide board staff with satisfactory proof of completion of the required CE within 14 business days of completing the CE. Respondent is not required to request pre-approval from the board before taking the courses. However, any courses taken that does not match the required content shall not be accepted as having met the requirements of this order. Respondent shall be responsible for all costs associated with this order. Respondent's failure to complete the CE may subject respondent to future disciplinary action by the board.
And looking at Bates page 8 indicates that it was sent to him by electronic, regular, and certified mail.
That's correct.
And that first page of the exhibit was the email that was sent to him.
Correct.
And looking at the next page, Bates page 9, what is this?
That's a tracking from USPS indicating that it was delivered.
That was a certified mailing.
Correct.
So did Mr. Quintana complete the CE as required by the order?
He did not.
Looking at what's been marked as Exhibit 3, specifically Bates page 14, that's the same email that we looked at in Exhibit 2, correct?
That's correct.
And going to the previous page, page 13, there's an email from Mr. Quintana.
Correct.
And what is the date of that email?
March 19th, 2024.
Could you kind of summarize that email for us?
The email indicates that he is having problems completing the CE. And at the end, he asked for an extension.
And when he's saying he's having problems, he also indicated that he mixed up the dates of when it was due, correct?
Correct, yes,
And you said he asked for an extension,
he did.
and was that granted?
He was granted a 2-week extension. He had asked for a 60-day extension.
Looking at Bates page 12, it's an email response to him approving the extension of 2 weeks.
Right.
Now, at some point, did he provide you with a response regarding whether he had completed the CE?
Yes, he did.
Okay. And looking at Bates page 11, there's an email dated April 8th, correct?
That's correct.
And he says, I hope these satisfy the requirements.
Correct.
And what did he list? What did he provide?
He provided the names of 2 courses that he completed for his CE.
Okay, and did you review those?
I did.
And did those meet the requirements of the order?
One of the courses met the requirements, the other one did not.
And on Bates page 11, halfway through the page, there's an email from you to him dated April 9th, correct?
That's correct.
And what does that email say?
An email says that the course entitled Maximizing Patient Safety and Efficacy with, forgive me for mispronouncing this, oxymetazoline, OTC products, and the management of nasal congestion, a pharmacist's guide to optimal use, pharmacy technician credit, does not qualify for the order as it does not address error prevention. Please complete another course.
And did he respond to that?
He did.
And what did he say?
He said that he was having a hard time finding free CE under patient safety, but he would look again.
Did he provide those certificates of completion with that email?
He did not.
Was he required to provide those certificates of completion?
He was.
Looking at what's been marked as Exhibit 4, could you identify this document?
The letter to Mr. Quintar from staff indicating that a complaint has been opened against his license for violation of a board order.
And that's the new complaint we're here on today, 24-0227.
That's correct.
And what is the date of that communication?
April 24th, 2024.
And if we can look at what's marked as States Exhibit 5, we have email communications.
That's correct.
And down the bottom is one dated May 3rd to you from Mr. Quintana.
Correct.
Could you summarize that for us?
It is Mr. Quintana's response to the complaint, in which he explains why he did not comply with the order.
And what was your response to him?
I thanked him for his response and let him know that the case would be forwarded to the Complaint Review Committee and the board for its consideration, and that if he completed continuing education in the meantime, to forward it to me to add to the complaint.
Did he submit anything further?
He did not.
Did he appear at the Complaint Review Committee to your knowledge?
I do not recall that he did, no.
And looking at what's marked as Exhibit 6, what is this?
This is a letter to Mr. Quintar notifying him of the consideration of his complaint by the Complaint Review Committee and the board at its June meetings.
Okay. And in that letter, he's given the dates and locations of those meetings?
Correct.
Did he appear at either of those?
Not to my knowledge.
And looking at what's marked as Exhibit 7, you identify this document?
That is an email to Mr. Quintar notifying him that the board had decided to forward his case to formal hearing.
And that would be after the June meeting?
Yes,
And with that is the complaint of notice of hearing in this matter?
correct.
And the issues stated in there were the failure to comply with the non-disciplinary order, correct?
Correct.
And looking at what's marked as Exhibit 8, you identify, is this his answer to the complaint?
That's correct.
And with that, he provided 2 certificates.
He did.
They both indicate completion on April 8th. Is that correct?
That's correct.
And these were received July 19th.
That is correct.
Were these submitted within the time frame set forth in the order?
No, they were not.
And are these the certificates of the same CE previously mentioned in prior correspondence?
Yes, they are.
And one of these you said was approved and the other one was not, correct?
That's correct.
The first one is the efficacy with oxymetazoline. That's the one you said did not meet the requirements,
And that's correct.
and that listed for 2 hours.
Correct.
And the second one has to do with error prevention strategies, correct?
Correct.
And that has for 1.5 hours.
Correct.
And that's the one you said was met the requirements of the order.
Yes, that's correct.
As we sit here today, has Mr. Quintana submitted any further CE to comply with the order?
No, he has not.
And based upon the documentation he submitted of the 3 hours that were required, how many hours has he completed?
1.5.
Thank you. Nothing further. And I would ask that states exhibits 1 through 8 be admitted into evidence.
Board members, do I have a motion with regards to the evidence?
So moved.
Do I have a second?
Second.
All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Mr. Hargreaves. Do you wish to make a closing statement?
Yes, thank you. As the evidence and testimony has shown.
Mr. Hargreaves, if you could push to,
Sorry.
thank you.
As the evidence and testimony has shown, Mr. Quintana was issued an order by this board to complete 3 hours of CE, was notified that if CE completed did not meet the requirements, they would not count. He was notified that only one of the 2 CEs he took was applicable to the order. He did not provide or complete anything further. The evidence shows that he is non-compliant with a board order. The state would ask that the board adopt as findings factual allegations 1 through 8 and 10 from the complaint notice of hearing and find violation of ARS 32-1901.01 C16, violating a formal order issued by the board, and impose whatever discipline the board feels is appropriate in this matter. Thank you.
Thank you, Mr. Hargreaves. The board will now discuss whether the state has proven the allegations. Board members, any questions or general discussion? Do we have a motion with regards to the factual allegations?
I move we accept the factual allegations.
Madam President, members of the board, would you consider amending that motion to just include, I believe. Sorry. I believe the state has withdrawn finding of fact 9. So, or factual allegation 9. So if we could just move to adopt factual allegations 1 through 8 and 10 as your findings of fact.
I modify that to be in that format.
Thank you so much.
Second.
I have a motion and a second. Any further discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Mr. Hargreaves, do you have a recommendation in terms of discipline?
I defer to the board.
Thank you. Board members, discussion?
Madam President, did we adopt the allegations as conclusions of law, the notice of charges?
I don't think so. We just did the findings of fact, so need to also be conclusions of law.
Maybe before we talk about the order.
Yep.
Yeah. Thank you.
I move that we adopt the findings of fact as
Conclusions of law.
conclusions of law.
Thank you.
Second.
It would be the alleged violations.
And alleged violations.
Yeah, thank you. Thank you.
And alleged violations.
Second stand.
Yes.
All those in favor?
Aye.
Any opposed? Deliberations on discipline?
This person has been a pharmacy technician for 30 years, it looked like. I do agree that them not completing CE and not complying with the board order is a serious offense, but I would imagine that they've had 28 years of completing the correct CEs. I was thinking maybe a decree of censure, so it would be disciplinary, but not further than that, in my opinion.
I'd also like to see the additional 1.5 hours of CE included that he's failed to provide.
But then didn't. Thank you. It also concerns me that he said he did it, but then not submitting anything. It seems like he's not telling the truth about the whole thing and for some reason not wanting to do it or can't do it. So that bothers me.
Mr. Falwell, if I could clarify that, he eventually submitted certificates that he said he completed. They just did not meet the requirements of the order.
Okay.
It's not a situation where he said he completed it, but he didn't. He just didn't comply with the specific requirements. He did do the CE. It just wasn't in the area it was supposed to be.
It was the wrong CE.
I got you.
Yeah,
Okay.
and the trouble though is that once it was made clear that it's not the correct CE, it wasn't rectified. I just don't understand.
And I do understand that there's costs sometimes associated with CEs, but like we're talking about like $10, $15 for most CEs, even if you can't find it for free. So we're not talking about like thousands of dollars. Just for perspective for the public members. You're not talking about something that I think would be an extreme burden for somebody. The other thing that concerns me is the fact that he's not here. So if he takes his license very seriously, why isn't he here for us to at least hear his side of the story as to what were their financial circumstances? I find it hard to believe that not finding free CE is a financial hardship.
Agree.
What I'm thinking for suspension until he resolve the issue and complete his CEs. That's what I'm thinking.
Did I read it correctly that his license is up in October?
What about, this is just another alternative thought. What about a consent agreement that would require him to complete the CE with some sort of a term and that he has to complete it prior to the renewal of his license or something like that? Because we're pretty close to the renewal deadline. I don't know. I do like the fact that there needs to be something disciplinary associated with that. I don't know that we need to take his license for this. It's 2 hours of CE. Again, the fact that he's not here doesn't show that he's not regulatable. He's been licensed for a really long time, but I would still like, to your point, to see the CE completed. And is there something else we need to address with the fact that he is not here and still hasn't complied?
Madam Chair, just one thought, if I make a recommendation, is maybe do a stay revocation order and then do your terms as far as complete your CE before the expiration date of your license. And if he doesn't, then the revocation kicks in. So we don't continue to deal with this situation.
That's a good thought, and maybe add in there like that he'll undergo another CE audit this cycle or something like that as well, since he's up for renewal anyway. And then we'll see if this was a one-time thing or if it comes back again.
Dr. Gandhi, would that stayed revocation show as discipline on his profile?
Yeah.
Any order that the board issues at this point would be a disciplinary action.
So it would look something like a consent agreement for stayed revocation.
It wouldn't be a consent agreement, Madam
An
Chair.
order for.
Correct.
Okay. So an order for stayed revocation, with a requirement also contingent in the order that he must complete the 2 hours of patient safety CE prior to the in addition to his normal renewal CEs for 2024 prior to the renewal cycle, and undergo a CE audit again for 2024.
Just moment clarification. I think it's just 1.5 hours that's missing.
Is it 1.5?
Yeah.
Yeah.
Is that good?
Yeah, so. Madam President, members of the board, I think what I'm hearing is to issue an order revoking his license, staying the revocation to the end of October, in which time he has to complete the 1.5 hours of CE. If he does so, then he's in compliance and he'll be able to renew his license. If he doesn't, his license will be deemed revoked rather than expired. And then there were some additional terms, like a CE audit, I think.
Yeah, for the staff to complete a CE audit on his 2024 renewal as well, because those are random.
Okay. There was also a discussion of a decree of censure, but this replaces that. Thank you.
Second.
I have a motion and a second. Any further discussion? Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
This concludes this matter. The decisions will be reduced to a written order and sent to the parties. Thank you for your attendance. Case 27C CVS Pharmacy, 27C CVS Pharmacy, number 7022, board case number 23-0199. Mr. Hargraves.
Yes, Seth Hargraves, Assistant Attorney General on behalf of the state. CVS will not be appearing. What you have in your packet is a signed consent agreement of what was initially offered by the board in this matter. The state would ask that the board accept that signed consent to resolve this matter.
And Madam President, I am recused due to my employment.
We would also need to vacate the hearing as well, right? Any discussion, or do I have a motion?
I'll make a motion to accept the signed consent and vacate the hearing.
Second.
We have a motion and a second. Any discussion? Dr. Gandhi?
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan's recused, Mr. Dang,
Aye.
Mr. Al Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Madam Chair. One recusal.
Thank you, Dr. Gandhi. Is everybody okay? We do the one more before Mark needs to take off? All right, 28A, Jeffrey Keith Souza, board case number 23-0609, motion for rehearing. Is Mr. Souza present?
I don't see him online either, Madam Chair.
Shall we proceed?
Hello? Hello?
Sorry.
I'm sorry. This
Hello,
is Jeff
Mr.
Souza. I'm so sorry, guys.
Thank you. This is the date, time, and place where Jeffrey Keith Souza's motion for rehearing is scheduled to be heard by the Arizona State Board of Pharmacy in case number 23-0609. Will the parties please introduce themselves for the record, starting with the counsel for the state?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Mr. Souza?
This is Jeffrey Souza.
Pursuant to Arizona Administrative Code R423-128D, the board may grant a rehearing of a case if Mr. Souza establishes that one or more of 8 grounds listed in the rule materially affect his rights during the administrative proceeding. The board has reviewed Mr. Souza's motion for rehearing and the response to the motion filed by the state. Each party will have 5 minutes to address the board on this matter. This is the time for legal argument related to the grounds for the rehearing, and the party should not use this time to present new evidence or testimony to the board regarding the merits of the case. Mr. Souza, in your arguments to the board, please clearly identify and explain the grounds that support your motion for rehearing. Mr. Hargraves, in your motion and arguments to the board, please clearly identify and explain why the state does not believe Mr. Souza is entitled to the rehearing. We will now proceed to the oral arguments. Mr. Souza, you'll go first.
Thank you very much. I just first want to apologize for taking your time for this. I take full responsibility for it getting this far. I was one credit short and had a $25 fine, and I let it get to this point, and I'm embarrassed, quite honestly. So I just want to apologize first. As far as legal grounds for this rehearing, I don't know if I have any like legal precedents to present. I apologize for being here. I have the money to pay this fine. I can pay it right now. I was planning on going down there and being there and turning it in today, but I have a situation where my wife just happens to be in the hospital, dehydration, so I couldn't make it. So I haven't made that payment, which is embarrassing again. But I can make that payment today. But again, I honestly don't have any legal precedents for my request.
Thank you, Mr. Souza. Mr. Hargraves?
Yes, thank you. Madam Chair, members of the board. Arizona Administrative Code R4-23-128D sets forth 8 specific criteria for the board to grant for an individual qualify for rehearing or review. Mr. Souza's request does not meet any of those. Little background: in May of last year, this board issued Mr. Souza an order for non-disciplinary civil penalty in order to resolve case 23-0250. That also required a civil penalty. Both the civil penalty and the continuing education were required to be submitted to the board by September 22nd, 2023. Mr. Souza did not comply. In November of last year, board staff opened a new complaint against Mr. Souza for violation of a board order. He was sent notice that the complaint had been opened and requested that he submit a response. November 18th of last year, he submitted an email response indicating that he would pay the civil penalty in full. Staff responded 2 days later, asking that he also provide documentation regarding his continuing education requirement. In December, staff informed Mr. Souza that they had still not received his payment or proof of the continuing education. He was also, that same date, he was sent notice that the matter would be reviewed by the board's complaint review committee on February 6th, and that committee's recommendation would go to the board at their February 2024 meeting. He did not respond or attend either meeting. At the February 14th meeting, this board voted the matter to formal hearing. February 21st, a complaint notice of hearing was issued notifying Mr. Souza that the matter was set for hearing on April 18th. It also notified him that he was required to submit an answer to the allegations within 30 days, and if he didn't do so, the board could deem the allegations admitted and take action without him holding the hearing. He failed to respond. A motion to deem was filed. The board granted the motion to deem, vacated the hearing, and revoked his license. On May 9th, an order revoking his license was issued. On May 30th, he submitted a request for rehearing. In that request, he indicated that he had showed up late for the May 8th hearing. He showed up and the doors were locked, only to find out later that there was another door he could have entered, which is quite difficult to believe considering the hearing was scheduled for April 18th, not date in May. He indicated he was here. There was no hearing in May. He has been given opportunity after opportunity, given notice to address this issue. He's indicated several times that he would and didn't follow up and do so. Again, the board's rules set forth specific criteria which he would need to demonstrate to show that he is eligible for rehearing or review. It simply has not done so. So the state would ask that his request for rehearing or review be denied. Thank you.
Thank you, Mr. Hargraves. Board members, any questions for either of the parties? Mr. Souza, I have one question for you. Why didn't you appear for the hearing when you were scheduled?
I will address the May 8th. I heard Mr. Hargreaves say there wasn't even a meeting for May 8th. that was, the information I got is I did have a meeting from May 8th. And ridiculously, I was not able to open the door and I did not know there was another door. The February meeting, I don't know if I had that information. I don't remember having, being told that there was one in February. I will say though, as far as the CE, I was only under the impression that I had this fine. I don't remember in any of my emails or the paperwork telling me about the CE needing to be completed. That could be my fault, but that's why I didn't complete the CE. But I absolutely would do that as well. And again, I just apologize for all of this.
Thank you, Mr. Souza. Any additional questions, board members? The board has heard the arguments of both parties and has reviewed the pleadings filed in this matter. The board may grant a rehearing in the event that it meets one of the 8 criteria.
I don't see that it meets the criteria, so I'll make a motion to deny the request.
Second.
I have a motion and a second for denial. Any discussion? Dr. Gandhi?
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lahan,
Aye.
Mr. Dang,
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. This concludes the matter. The board's decision will be reduced to a written order and served to the parties. The parties will have further appeal rights that will be explained in the board's order. Thank you for attending today. Thank you, Mr. Harris. We'll take a brief break so that we can rearrange here. 10 minutes. Everybody back? Welcome back, everybody. Dr. Gandhi, if you can direct me, I think we had one request to go early. 24C, is that right? Huh?
Looking right now, Madam Chair, one moment.
Due to a conflict later in the day?
That is correct, Madam Chair, 24C.
24C, complaint number 24-0104, Joseph Andrew Blunier. Is Mr. Blunier present? Hi, if you could please introduce yourself for the record.
I'm Joseph Blunier.
Welcome, Mr. Blunier. I see Miss Mitchell approaching. Miss Mitchell, if you could give a brief summary.
In March 2024, Joseph Andrew Blunier entered into an interim consent agreement for interim suspension of license. The consent agreement became effective on April 22nd, 2024, and his license remains suspended. The board considered this complaint at its June 2024 meeting, and after review and discussion, the board directed staff to request a copy of the evaluation that Mr. Blunier underwent for the Illinois Board of Pharmacy. Staff obtained the investigative files and evaluation report from the Illinois Board. The documentation is included in the board's materials, and the matter is being returned to the board for consideration of the evaluation and to determine the next steps in the case. On August 20th, the board office received a copy of a consent order from the Illinois Board of Pharmacy. The order indicates that Mr. Blunier's license in that state has been surrendered.
Thank you, Miss Mitchell. Mr. Blunier, would you like to make a statement before we proceed with questions for you?
I was under the impression that at the last meeting, somebody had asked that I have an assessment done, which I had done through the state of Illinois, and that's what I was under the assumption that's what was being requested. Was that received also from Illinois?
That, I believe, is the new evidence that we have. Board members' questions for Ms. Mitchell or Mr. Blunier? Discussion?
So you've surrendered your license in Illinois?
Yes, ma'am.
Is that your intention in Arizona as well?
I would like not to. No. I understand what I did was horribly wrong. I have paid numerous consequences from having this happen. I have also, without the help from either board, I was not allowed to participate in the pharmacist assistant program in Iowa. Illinois did not offer me any kind of support in their pharmacist support program. They just immediately asked me to surrender my license. I have got clean by myself. I celebrated 1 year of sobriety 6 days ago. I have been in therapy since August of last year, right after this happened. I am currently working a full-time job for the Iowa Army ammunition plant, helping to serve our troops. I am thriving in that role and thriving in my sobriety. I'm on the path and to request for my Iowa license to be reinstated in October. And then Illinois is very difficult to get in touch with. But all that I can get from them is that once my license in Iowa is reinstated, then I can apply for Illinois to be reinstated, which I don't really understand, but I'm just trying to do what's expected of me. Like I said, I feel like I have done everything that I can to try and fix this problem that I have caused. And again, I've been a pharmacist for 14 years, and I made a grave, huge mistake, not to minimize it at all. But I have done my best to try and remedy that situation and to make the changes needed so that I can at some point return to a pharmacist. I don't plan to work as a pharmacist anytime soon, at least next year. But I just don't want to lose my home license, which is Arizona, and I've continued to keep my CEs up. I just would like to, if you want to keep it on probation or suspension or however you feel appropriate, I am okay with that. I just would really like to not have to surrender this license.
Thank you, Mr. Blunier. Board members, questions?
Mr. Blunier, congratulations on your 1-year sobriety. That's a great milestone. We understand that your license has been revoked in Iowa and you've relinquished it in Illinois. What's the compelling reason why this board should keep your license active or not ask for it to be relinquished or revoked here in Arizona?
Well, Iowa, both of them requested me to surrender it. I was not given an option in either case. And as I said before, I feel like I've really put the work and the effort in to show the changes that I have needed to make and get the help that I needed. Again, alone, as no pharmacy board has even wanted to offer me any support. And so it's just been frustrating and alone and lonely. And I just need a win. Like I've been kicked a lot while I've been down over this last year. And for me, this would just be a win. And I just need a win. And I would just not like to lose my home license. And I guess I would ask, if what I've done is not enough, then what would you request that I do to show you that, like, I am making these amends to again be reinstated, to the profession of a pharmacist?
Mr. Blunier, you had mentioned that your the state that you reside did not allow you to participate in their professional recovery program. Are you able to voluntarily enroll in their program?
No, because I don't have a license here. That's the frustrating part. I can't participate in Iowa's. I can't participate in Illinois because they just took my license.
Just curious, the evaluator mentioned something called Catechus group.
Oh, Caduceus group?
Caduceus? I'm not familiar with what that is. Do you know what that is?
Yes, it's a kind of like an AA meeting, but it is like AA meetings that is based with healthcare professionals. They are difficult to find in my area. And so I've been doing other online like NA meetings and AA meetings. AA meetings are just not that I have an alcohol issue. Just with talking with my therapist, AA meetings are more an official, I don't know, it's hard to explain, but I've been attending the AA meetings on an app called In the Rooms, which has meetings any time of the day, anywhere on Zoom. And they have one that's kind of supported by nurses, and they've been really accommodating to me as a healthcare professional. But there was a Caduceus meeting that was online in Idaho that meets on Thursdays at 7 p.m. But at the ammunition plant, I work 5 p.m. to 3:30 a.m. Monday through Thursday. So I can't make that meeting, and I've been unable to locate any other Caduceus meetings locally or online. Zoom, a lot of them ended their Zoom platform after the pandemic was done. So
Thank you. We do have the evaluation that was completed by Illinois, and while it is not our typical evaluation, the quality of it is not as comprehensive as what we would normally see. Looking at the evaluation, according to the evaluator, he does not have any impairment that would require any type of practice restrictions, is what I see. And they do recommend treatment. So the underlying conduct is still very concerning to me. However, he has been sober for a year. How long has his license been? Has it been in a suspended status? Staff?
It was suspended on March 8th, 2024.
Okay.
And Mr. Blunier, just for clarity, you did not disclose to this board the issue that happened in Iowa. We found that out through an alternate notification. Is that correct? You did not make notification to us, letting us know that there was an issue with controlled substances in Iowa?
that is correct, and I take responsibility for that. That was a misunderstanding that I had with the state board in Iowa. I was under the impression that they were notifying Illinois and Arizona, and so I thought that met the requirement, and I failed to do that. But I do take responsibility for missing that.
I'd like to make a motion. I think looking at what you've done on your own, and I commend that. So I think you should have the possibility for steps back into the profession. And I would make a motion for a PAPA contract that's standard contract, which would be 5 years.
Second.
Any further discussion?
So I would think he would also need to contact Papa so that he can understand what the requirements are, particularly not living in the state of Arizona, to meet the requirements of the Papa contract. So I think do your homework, Mr. Blunier. Contact Papa now so that you know what the expectations are going to be if this board does offer that.
Could we also add to the motion, Mr. Hargreaves, Ms. Galvin, that if he does not sign, that we would also accept a voluntary surrender?
You may.
When you say standard PAPA contract, are you talking about the period of suspension followed by probation? Or I believe the standard one has been, was it 6 months suspension?
6 month suspension and then 5 years probation.
Yes, that is what I mean.
So no credit for the time served already. He's been suspended since
He's not even
March.
practicing here, so I don't see that being an effect.
Okay, so an additional 6 months suspension.
Honestly, I could take or leave. Doesn't matter.
I think give him credit for time served.
Okay.
For discussion.
All right. Then I'll amend my motion.
I amend my second.
Is everybody clear what the motion is?
Yes.
Okay. A motion and a second. Any further discussion? Dr. Gandhi?
Thank you, Madam Chair. Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Mr. Blunier. We appreciate you being present. Staff will be in communication with you on the order.
Thank you so much. Is the information for the op information on the state board website?
I believe it's on the State Pharmacy Association's website. Is that correct, Mr. Gandhi? Or is
Yes,
there a link on our site as well?
don't believe it's on our side, but
You will receive an order, proposed consent agreement in the mail, and you have the option to sign with either the Papa organization or Community Bridges. And that contact information will be on the order.
That's perfect. Thank you guys so much. I really appreciate it, and I will not let you down.
Thank you. Best of luck to you.
Thank you.
Dr. Gandhi, are we going to conferences next, or are we going back to 22? Or Ms. Cannabong?
You may wish to go back to 22.
Okay, so we'll go to 22A. Novum Pharma LLC. Renewal applications requiring board review. Is anyone present from Novitum?
Yes, hi, good morning. This is Chad Gasser.
Mr. Gasser, what's your role with Novitum?
I'm the CEO of Nividium.
Thank you very much. Ms. Mitchell, can you give us a brief summary?
Certainly. Novum Pharma LLC holds a non-resident manufacturer permit with this agency. The permit was issued on September 14th, 2022, and was set to expire on October 31st, 2023. Novum did not renew their permit during the renewal period in 2023. Instead, on March 6, 2024, the company submitted a new manufacturing permit application indicating that they had undergone a change of ownership, with the former permit number being M002027, which is the permit under consideration today. While reviewing this application, staff discovered undisclosed disciplinary action from Arkansas in 2023. A deficiency notice was issued to the applicant requesting information concerning the date of the ownership change and an explanation for failing to disclose the disciplinary action on their Arkansas permit. In their response to the deficiency notice, the company indicated that they didn't have any denial letters and had erroneously submitted the change of ownership application and simply needed to renew their existing permit. They also indicated that they were unaware of any disciplinary orders from the Arkansas Board of Pharmacy. They submitted their renewal application on May 3rd, 2024, and did not disclose any disciplinary action or denial letters.
Thank you, Ms. Mitchell. Mr. Gassert, anything you'd like to add?
Yes, and thank you for the opportunity to explain the situation. At the time of the submission of the renewal application, we were not aware of the Arkansas open action. As a matter of fact, we learned from the Arizona Board of Pharmacy about this action, and we immediately reached out to the Board of Arkansas. We did learn that the open action was a result of a delayed filing of the change of ownership. And we also conducted an investigation internally as to how we missed any notifications from the Arkansas Board of Pharmacy. And we learned two things from that investigation. One, the notifications were sent to our manufacturing facility as opposed to the third-party licensing organization that previous notifications have been sent to. And two, with the notice being sent to the manufacturing facility and following the acquisition of Nividium, we had relocated a number of corporate executives to a different location, and the mailroom system was not in order to forward the communications that were received at the manufacturing facility. And so what we now have implemented several corrective actions within the manufacturing facility mail room operation to assure that mail that's coming to that site for individuals that are not located at that site are not properly organized and transported to the sites where those individuals are located.
Thank you, Mr. Gassert. Board members, any questions?
I guess I'm confused. You're saying that there was a change of ownership? And then in the summary, it says that you didn't want to file a change of ownership or did I misunderstand that?
There was a change of ownership in late 2021. And we filed for that change of ownership.
That's correct. The application that is under or up for renewal was that change of ownership application. So that's been accounted for.
Thank you.
So Mr. Gassert, between November 1st, 2023, when your permit was expired, and March 6th, 2024, how many units did you ship into Arizona?
Novum did not ship any units into Arizona during that period of time.
So it appears to me that it was a failure to disclose disciplinary action. So I'll make a motion for a $250 non-disciplinary fine for that.
Second.
And upon payment to renew the permit?
Yes, upon payment, renew the permit.
Yes.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Hearing none, motion carries. Thank you, Mr. Gassert, for being present. The board staff will be in communication.
Great. Thank you for your time this morning.
Thank you. 23A, Cody Scrimshaw.
Hello, I'm here.
Ms. Scrimshaw, if you could please introduce yourself for the record.
Cody Scrimshaw.
Welcome. Ms. Gertie, if you could introduce yourself and give us a brief review.
Good morning, board. My name is Sharon Gertie. I'm a licensing administrator. We have Cody Scrimshaw with us this morning. She applied for a pharmacy technician license on February 21st of 24. Ms. Scrimshaw disclosed on her application that she had a California CNA license, but failed to disclose that her CNA license was revoked in September of 2016. She also failed to disclose a felony conviction which occurred in 2015. Ms. Scrimshaw currently holds a pharmacy technician trainee registration with this board, which will expire in January 31st of 27. Records indicate that Ms. Scrimshaw's CNA license was revoked due to her conviction for willful child cruelty, possible injury, or death. Ms. Scrimshaw was charged with felony child endangerment in 2015. Details from this incident that resulted in Ms. Scrimshaw's conviction are unavailable. Documentation from the San Bernardino County Sheriff's Office indicates that Ms. Scrimshaw's request for the records and documents related to her arrest were denied due to confidential nature of the investigative records. On August 18th, 2015, Ms. Scrimshaw was convicted and sentenced. A diversion program was offered as a modification of probation, where Ms. Scrimshaw was ordered to attend a drug treatment program. On May 30th, 2017, Ms. Scrimshaw appeared in court where her charge was reduced to a misdemeanor and dismissed due to completion of her diversion program. Her sentence was vacated.
Thank you. Ms. Scrimshaw, would you like to make any comments?
Yes, so the charge was for the child endangerment. What had happened during that time, I had fell asleep and my 2-year-old son had gotten out of the house. I fell asleep while I was putting him down for a nap. And California Highway Patrol had seen him near the road playing, and so they brought him over to the house. I was involved. It was in an abusive relationship at the time, and so I was currently moving out of that apartment. And my son's dad had kicked the door down, and that's how my son was able to get out. And so I was arrested, and I'm sorry, that was a really traumatic time of my life, so it's hard to explain. It was pretty emotional, but I did go through all of the steps. I did get my kids back early. I got them back in 6 months, and I did everything I could to change my life. I did actually get the revoked status off of my CNA license recently. And yeah, that's pretty much it.
Can you explain why it was drug diversion program that you went through? How's that connected with the child endangerment?
Yes, so at the time I was under the influence, and I admitted to that. And so during my court hearing, I was offered the drug court, and so I took that. I do have 10 years clean as of August 6, 2024.
Under the influence of what?
Of meth.
Ms. Scrimshaw, is there a reason why you didn't answer truthfully on the application?
For the disciplinary action, it was kind of confusing for me. I thought disciplinary action meant if it was something that happened on the job as a CNA. So I answered no on that part. And as far as the felony part of the application, I did read on the Board of Pharmacy website that I'm not required to disclose a single misdemeanor if it was more than 5 years ago. And so that's why that wasn't disclosed as well. It was just, I was confused. It's been a confusing process, but I have been, it's been a learning process for me.
Ms. Scrimshaw, you currently hold a pharmacy technician trainee registration here in the state of Arizona, correct?
Correct.
Are you working as a pharmacy technician trainee?
Yes.
How long have you been at your current job?
I just started on July 29th.
Oh, very soon. Did you work as a tech trainee before that at another location?
Yes, I was working at Amazon Pharmacy, the warehouse and the shipping department.
And your tech trainee license doesn't expire until 2027?
I believe so.
But you recently got certified?
Yeah, I got certified in February.
Staff, can you confirm if those charges needed to be reported to us or not?
Looking it up, Madam Chair.
Based upon information that we had, it appears that it was initially felony. It may have been reduced to a misdemeanor. The question on the application, in that situation, it does not need to be disclosed if it was more than 10 years. I believe it was within that 10-year time, so it would have had to have been disclosed. If it was a misdemeanor to start out with, it would have been 5 years.
Thank you. That's helpful.
If she would have waited until her tech trainee registration was expired in 2027, would she have had to disclose then?
It looks to me on question 6, I don't see the time frame on that.
Third line.
Oh, thank you. Yeah, thank you. I still am concerned about the drug use period.
Yeah, I agree. I mean, that's
Any type
that's
of
my concern.
history is concerning to me.
Ms. Scrimshaw, did you have to pass a pre-employment drug test from either of your pharmacy employers when you started working?
Yes, from both.
Sorry, I didn't have my microphone on. They would have reported that to us if there was an issue. Or should have.
Should have.
Did you disclose those charges to your employer?
I did not, and the reason why is because, when I had the case originally, I was told by the judge and the public defender that upon completion of the charges that I didn't have to disclose any felonies because my record is now clear. So I don't disclose it.
Staff, does she have a valid fingerprint clearance card? Yes, she does.
She does.
Based on the time that we're talking about and the fact that she's passed pre-employment drug screenings that would have had to have been reported to us if there was an issue, I would personally be comfortable with issuing the license with two $250 fines for failure to disclose, one for the criminal history and one for the issue with her nursing license. I understand she didn't understand the question, but she could have called and had a conversation with the board staff if she had questions. That's kind of where my head is.
Do you think giving order to do like a test like now, like within 2 days, just like the same we did yesterday, just to confirm like she's clean or she's sober?
I don't think we've typically done that in the past. It was 10 years ago. If it was something a little bit more recent, I would be more inclined to do that, but I mean, we can discuss it.
On the disclosure, I'm not sure as you are on that. I think that type of wording there can be confusing as well. And that I would give her grace there.
So what are you recommending?
No, I go with the recommendation, like with other recommendation, 250 for non-disclosing and approve her application.
So 500 or 250?
250, right? Is this 250?
I said 250.
250 for each one? Okay,
Yeah,
so total
500.
500, yeah.
And I would think it would be just 250 in my mind.
Somebody would
I
like to make a
second that
motion?
motion.
I didn't make a motion, but
Oh, I thought that was your motion.
no, I was
Oh, we thought
it was
that's-
just discussion.
I'll make a motion for $250 non-disciplinary penalties for non-disclosure.
Second.
I have a motion and a second.
Do you want to address the application?
Yes.
Approve the application upon payment.
Amend my second.
We want to do a roll call or is voice good enough?
We can do voice.
Okay. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Ms. Scrimshaw, the board will, staff will be reaching out to you.
Thank you so much for your time.
Thank you. Appreciate it. 23B, Rachel Faye Walker. Is
Hi.
Ms. Walker present?
Yes.
Good morning. If you could please introduce yourself for the record.
My name is Rachel Walker.
Ms. Gertie, if you'd like to give us a brief summary.
Of course. We have Rachel Walker today who applied for a pharmacy technician license on May 23rd, 2024. Ms. Walker failed to disclose 5 criminal charges on her application as required by statute 32-1921, section A. According to police records, Ms. Walker was arrested in April of 2002 on 2 charges, possession of methamphetamines and being under the influence of methamphetamines. Ms. Walker was unable to obtain copies of her court records due to the age of the case. Ms. Walker indicated that she was required to attend a drug diversion class for 3 to 6 months and also attend weekly NA meetings. She maintains that she fulfilled all of the requirements of her sentence and the case was dismissed. According to court documentation, Ms. Walker was charged with 3 felonies in 2005: burglary, taking of a vehicle without owner's consent, vehicle theft, and making, possessing, and uttering fictitious instruction. The circumstances which led to Ms. Walker's arrest are unknown, as her request for the police report regarding her arrest was denied by the San Bernardino County Sheriff's Office. Board staff requested disclosable portions of the arrest record, but have not received a response from the police department. Ms. Walker accepted a plea deal and pled guilty to felony burglary with all other charges dismissed. In 2008, upon completion of her sentence, Ms. Walker's charge was reduced from a felony to misdemeanor and her case was closed.
Thank you, Ms. Gertie. Ms. Walker, would you like to make a comment?
I think about the vehicle situation. It was actually a car that had been bought, and the person that I was with, like, we didn't know that it was, I guess, already stolen when we bought it. So that was that situation. I think that's all I want to say. I mean, all of this stuff is like so old that I don't really remember everything. I just know that I took care of everything and I've been good to go for like 20, 25 years now.
Why did you answer the question on the application as no? Regarding your criminal history.
Because I thought because it was so old, I thought that like it like went off your record after like, I thought it was like 10 years or something, because in California, I think it's different. So I just answered it like that. But then when I got the email saying they needed all the information, I obviously went ahead and got all that information and sent it in.
Can you tell me more about the fictitious instruction? What does that mean? What's that?
You know, I actually don't know. I know that when I talked to Sharon on the phone before, like, she submitted all the documents, she asked me that question too, and I don't know. I thought that just had to do with the other person I was with, so I just didn't really pay attention to it because I honestly don't know what that means.
And Ms. Walker, you received a good cause exception with the Arizona Board of Fingerprinting, correct?
Yes.
And are you currently sober today?
Yes.
If there's no further discussion, I'm willing to make a motion.
Go ahead.
I'd move to approve the application upon payment of a $250 non-disciplinary civil penalty.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Ms. Walker.
Thank
Board
you.
staff will be in communication.
Okay, thank you.
Thank you so much.
Bye.
We're going to conferences. 25E, complaint number 24-0003. Cornelius Tani, in Gilbert Pharmacy. Please have a seat, sit down and introduce yourselves. Make sure you push the microphone button.
Good morning.
Good morning. My name is Cornelius Tani
My name
from Gilbert Pharmacy.
is Terrence Tani, also his son, and from Gilbert Pharmacy.
Are you a pharmacy technician as well?
Intern.
Oh, sorry, pharmacy intern. Mr. Jacobson, Mr. Hyber, if you'd like to introduce yourselves and one of you provide a summary.
Good morning, Board of Pharmacy members. This is Max Jacobson, Arizona Board of Pharmacy Compliance Officer.
Good morning, board members, as well as Steve Hyber, Compliance Officer.
Gilbert Pharmacy applied for a relocation, but due to unforeseen circumstances, the relocation opening was delayed. The pharmacy remains closed and has been closed for over a year now. Compliance officers conducted an opening inspection in March of this year, and several issues were identified, including the security of the drugs due to a non-intact barrier, prescription-only drugs, including controlled substance that were moved into an unapproved space. The PIC was unable to provide any controlled substance inventories for the past 5 years. The PIC was also unable to provide any controlled substance invoices, reverse distributor documentation, and it was discovered that the previous pharmacy location had been robbed several times and no DEA 106 forms, that's loss of controlled substance, were filed with this Board of Pharmacy. Furthermore, a drug audit was performed by myself and Officer Hyber. And due to the lack of documentation, we just went back to the starting of the pharmacy in 2018. So we started with a 0 inventory. Dispensation data was taken directly from the pharmacy's computer system. Wholesaler and reverse distributor information was petitioned directly from those organizations. Myself and Officer Hyber counted 18 controlled substances while we were on site. Of those 18 drugs that were audited, 8 had a negative variance of up to 1,124 tablets, which was 18.7% short. 7 drugs had a positive variance of up to 716 tablets, which was 44.8% over. 2 drugs had no variance, which balanced with the records. And 1 drug was unable to be analyzed due to unclear dispensation reports. The written response from the PIC is attached in your board book, and the pharmacy remains on administrative hold at this time. They have not been operational since July of 2023 per dispensation reports. And as of Tuesday of this week, the PIC stated that the security issues have been resolved and they are now ready for an opening inspection.
Thank you, Mr. Jacobson. Go ahead.
Mr. Jacobson, you say their medication was in an unapproved space. Where was it?
Yeah, so they applied for a relocation. So they moved their drugs from their old pharmacy to the new location space. The way it typically works is a compliance officer would go in and do an opening inspection or a relocation inspection to approve that space. Mostly that inspection entails security and equipment for the pharmacy.
That's what I was headed. I was going to ask about security and temperature of the space that the medication was stored at.
Correct. During the relocation inspection, it was identified that there were several holes in the exterior barrier that were pointed out to the PIC and Terrence as well. Pictures were taken, and it was very well documented of what our concerns from a security standpoint were. Furthermore, the way the pharmacy is set up is they have a RX only area, the pharmacy area, then they do have an OTC area outside. The RX only area that had drugs moved in before we approved that space was climate controlled. There didn't seem to be monitoring or documentation of that climate control, but when we were in there, it was air conditioned. The OTC area was not. It was fairly warm, and those concerns were identified to the PIC and Terrence as well.
So same concern, cleanliness, rodents, I don't know. Was that observed there, having holes in the wall? Just curious.
So the holes were above the ceiling, similar to a drop ceiling like this. There are holes, and the concern there is that from adjacent suites, somebody could climb over and access the pharmacy area. I wouldn't categorize this as much as sanitation failure as a security failure.
So they moved all their medication to unapproved location, right? And did they, this location, the new location, has a different DEA number? Did they transfer the DEA address to the new location?
Yeah, I'd be happy to answer that. They failed to notify the DEA to have their registration moved to the new location. So they actually have issues that they're going to have to address with the Drug Enforcement Administration as well.
Exactly, because this is also another concern, storing control medication with unapproved location by the State Board of Pharmacy and by federal agency DEA.
Mm-hmm. And I'll just add one thing about the OTC portion of the facility. It did appear that it's a larger facility than a small pharmacy. So it did appear that the AC unit or the HVAC unit for that area had been, turned off. Maybe it was cost saving and maybe the unit wasn't functional. But most of the drug that we found up there, the OTC drugs, has reached its expiration date. And we noted that to them.
And the location is not operational, so nobody there. They just store the medication there, right? So nobody monitor the temperature. If there is power outage, nobody took any action. Who knows what's happened there? And
That's
just another
correct.
concern,
I
yeah.
did make several unannounced visits to the location, the new relocation address, at which time nobody was present in the building. I did also with Officer Hyber and make a couple of scheduled visits where we met with the PIC while they were there. And during those visits, it did seem like the temperature, at least of the RX only area, was appropriate.
At that time, right?
Correct.
Because
But
nobody knows what's in-
like I was stated earlier, there was no documentation of temperature or humidity controls or environmental controls for that concern.
Because pharmacies are required to track the temperature like manually or electronically. So just to assure the safety and the right storage for meds. So I'm just saying like many violation there, not one, not two, not three, and including the DEA violation. And in addition, failed to do the May 1st inventory, like this is also state and DEA because DEA required every 2 years as well.
Mr. Tanya, would you like to make a statement?
Sure. At the time, they're talking about we did not have a temperature control. But later on, we learned that we had to keep log of the temperature 2 times a day in the rooms, 4 rooms. So we are keeping that log down. Yes.
Thank you. Is there anything else you'd like to add? Or would you like us to go ahead and ask some questions of you?
Do you have anything to add or ask? No? Okay.
Okay. Board members?
I'm sorry, go ahead. I just like to hear from you, just if you give us summary about the whole situation, like a brief summary. And if you can get just closer to the mic, so because I couldn't hear you when.
Okay.
Yeah.
Okay.
You can slide it forward too a little bit.
Oh,
Just be
slide
careful you
forward.
don't unplug it.
Okay, thank you, thank you. So we decided to move to a new location. When we made the decision, and because the old pharmacy, there were inconveniences. We had 2 burglaries, which prescriptions were stolen. In fact, 3 of them, 1 of them, nothing was stolen. So we decided to move to the new and bigger location, much more convenient. We did make notifications to DEA, especially. I notified DEA that we're moving because we had controlled substances to move. That's whom I thought at first. And then I think I notified the board to later on that we're going to move. Excuse me. And then we did move the drugs. We moved the drugs and kept from 106, which the officer talked before. We did have the Form 106. We had that form in the folder. So we're fine with that, and I think the other forms we had those. Any other thing you want to add?
I'd also like to clarify a few things. The new location, I think one of the officers stated that it's ready. We are still actually working on getting the holes that they identified patched up, so that's not ready yet. But about we did not notify the
Board of Pharmacy about the moving of the drugs, only the DEA. So that was a failure on our part. We did not know that we had to also notify the Board of Pharmacy. But the new location, it's not operational at this time. As they've stated, it hasn't been operational since last July, I believe. And of course, we understand that there are many things that need to be completed, both documentation-wise, and making sure that all the compliance issues that are not met are done before we are ready for the opening inspection. So we actually don't intend to operate because we understand that there's a lot of things that need to be fixed, if that makes sense.
You said you notify, I mean, I cannot speak for the DEA rules. We're not here to discuss DEA rules, just to make it clear. But when you do change address for DEA, there is like form you submit. You just notify them. I could be wrong. And now if you go to your DEA license, what address does it show there? If you now go to DEA license, does it show the current address or shows?
The DEA, we've worked with them for many years. They would not issue a revised DEA registration certificate unless it matched exactly what was on our board profile.
Correct.
Because we've had calls from them if it's off so much as a digit.
Correct.
You know.
So it's not just a matter of notify someone. There is a process there. And I believe our compliance officers, they help pick or pharmacy managers with the process. So I don't want to just steer the issue to relocation, not notifying the board. There is many issues there. It's not only one, so I don't see the pick or the pharmacy manager, they've done a good job with just daily basis, compliance to manage a pharmacy. And this 700, 1,000 shortage of this is a violation by itself. I'm not reporting to DEA. So I don't know. So have you practiced as a pharmacy manager before you own this pharmacy?
No, I've never been a pharmacy manager before, but I did help the pharmacy manager where I was for 23 years. I worked with him, but I wasn't, I didn't have hands-on moving products. So when it's time to move products or to change locations, I never did any of those.
Okay.
What about the simple task of taking an annual controlled substance inventory? You haven't taken one since you opened. So that's an annual requirement.
Annual requirements. No, I did not do any of those. I helped him with some other duties, but.
How long have you been a pharmacist in the state of Arizona?
23 years.
There seems like there's a lack of understanding on the rules that are required in the state of Arizona for pharmacists and pharmacy managers. It might be useful for your company to hire a pharmacy consultant to provide some education, because with as many violations as there are, it doesn't seem like you'd be successful going forward without a little bit more education on to the rules that you're required to follow.
And to the point that, Terrence, you're an intern getting mentorship from this pharmacist. I have a problem with that too.
Mm-hmm.
You're not role modeling great behavior for your intern to become a successful pharmacist.
Mm-hmm. I do have, the pharmacist does employ the services of a pharmacy manager, somebody who has had experience with, moving drugs and all whatnot. She comes in to help. She's not an employee. So when we need her help, she comes in to help us.
She's not doing a good job.
Yeah.
What?
Yeah.
How long has she been a pharmacist?
She has been a pharmacist for 20-something years too. So she actually helped us a lot with compliance issues. But yeah.
What
I-
happened to the patients? So you were open before. You closed your doors, you've been closed for a while. There's a notification for you to transfer the records to another pharmacy so that those patients aren't left high and dry. What happened to your patients? Did you transfer those records to another pharmacy?
We transferred most of the prescriptions to other pharmacies before we moved from the old location.
Did you give our patients?
We gave so the patients that were returning patients that would pick up normally, we did notify them. And then we had a lot of patients, so we left a voice message. So when they called, that they heard that, hey, Gilbert Pharmacy is closing down temporarily, and that was the first message they got. So they had the option to, give us a call if they wanted to transfer to a preferred pharmacy. And we tried our best to, make sure everyone was accommodated that way.
So what happened after you closed? So you weren't open. Anybody that you didn't transfer their prescriptions, what happened to all of those people?
Well,
After we closed, we notified those who wanted to move. Some of them did not. In fact, some of them came back and said, okay, I want my prescription to stay here. So we told them, no, we cannot leave them here. We need to transfer them to another pharmacy. And we did most of them.
I'm thinking probation. I'm just going to start the conversation, but probation for a year, I believe, might be adequate. And then a consultant and a reinspection. I don't know what time frame for the reinspection, like 3 months.
I have more concern there. My first concern about the medications that are stored, I don't think they should be usable for public, since this medication should not be used for sure. I have another concern about being picked. I believe we can do something like within the probation to 3 years, whatever we agree to, that not able to be preceptor or PIC for any pharmacies. And plus, I believe like I see when it comes to control medication, this is always like a state priority, like about having like 1,000 of, which medication has shortage? Do you have specific meds?
Yes, we do have that information. The drug audits reconciliation is on page 4510 of your board book.
The problem with that, Tariq, though, is I don't know if we really know what's missing because they haven't been keeping accurate records.
Yeah, correct.
So, I mean, they're only as good as you could replicate.
So that was our concern as well. And that's why we started with the opening of the pharmacy as zero inventory. We petitioned all of their wholesalers for all of the drugs that came in, and we ran reports going back to that opening day of the pharmacy as to how many have been dispensed. I think there were some concerns about record keeping, and that's why we handled it that way. We kind of took it out of the pharmacy's hands and put it in the wholesaler reverse distributor. And then we ran the reports from the computer system ourselves.
And how many of these were accounted for by the 106s from the break-ins?
So I have the 106s in your packet on page 4527.
I thought you said nothing was taken during the break-in.
So there were, correct, there were several break-ins, and in one of the break-ins, there was nothing reported missing.
To Ms. Nair's point, I think that we should consider imposing civil penalty of $1,000 for multiple violations here, in addition to all this items that Ms. Nair had mentioned.
Madam Chair, if I could clarify, the credits for the DEA 106s that were submitted to us, they were accounted for in our drug audit.
So the shortages that are listed are over and beyond of what the 106s were.
That's correct.
So those based on the work that you performed with the with the wholesalers and the reverse distributors based on their dispensing records would reflect true shortages.
That's
for all those
correct.
drugs. Okay, super helpful.
And how many prescription a day average? Like how many prescriptions a day, like average, you used to dispense? How many?
Per day? No, I don't have the information.
But like in general, like in a normal day, 50 prescriptions, 100, 500?
No, I mean, it was
No.
small and we weren't
Small.
that busy, maybe less than 100. I mean,
Okay. So less than 100, and you have a pharmacy manager,
Maybe
pharmacist,
50.
and you, right? And an intern,
Yes.
basically, like three.
Well, I work
He's
for
not always
Walmart.
there.
Yeah, I work for Walmart and while I go to school.
Okay. So it'd be you and another pharmacist, right?
Again, the other lady comes in.
Could you speak into the mic, please?
Once, oh, I'm sorry. She comes in once in a while to help me out. In case I need help, I call her. She doesn't come in every day.
So I know you were thinking, Kevin, potentially a fine. We're talking about, I've heard a number of different things discussed. So destruction of their inventory, since we don't know if it was maintained at an appropriate temperature. We're talking about making them hire a consultant, pay for an additional board inspection. Potentially, Mr. Tanya cannot be a preceptor or a PAC, which would mean he has to hire another pharmacist. These are pretty big barriers, especially for an independent pharmacy to overcome. I don't know how many dollars of inventory you have, but could be a lot of money. I don't know that I think the additional civil penalties are necessary. I think the rest of that is pretty stiff in my opinion. Just my personal opinion.
So, to Mr. Anderson's point, one thing that it bothers me is that you've been a pharmacist for more than 20 years. Your son is a pharmacy intern. Both of you are not good role model for our pharmacy profession at all. It clearly have demonstrated to us that you have neglected the importance of the basic pharmacy practice, basic annual inventory. You need to be aware of the proper medication storage. Those are the basics, but both of you have neglected to adhere to those basics. So I feel that both of you are not good role model for pharmacists nor pharmacy interns. And help us understand why did both of you have chosen to neglect those basic fundamental practice of pharmacy professions?
Like the things that you alluded to, you can see that those were not neglected. 3 break-ins, which we did make sure that the place was secured. In fact, if you see how the people broke in, even with a safe, I keep my controls in a big safe, locked. You could see them through the photographs. You could see them crawling and using a saw.
I don't know that I think that that's relevant.
I don't think
Yeah, that's not relevant. I'm
to this
talking about the
conversation.
annual inventory, the record.
I mean, Kevin, I think it's clear that he doesn't understand the laws of the laws and the rules of Arizona. He's been a pharmacist for a long time. It is concerning to me. I think we should look at also imposing some sort of something to him, whether it's CEs, potentially disciplinary CEs around law, or we also, I think, have as an option, we could also make him retake the MPJ, correct?
I'm fine with that.
Is that an option, Ms. Galvin?
Yes, it is. If I have one question. So they
Yeah.
haven't been operating for over a year. I heard testimony, the holes in the wall and the ceiling are still there. Are they interested in surrendering the permit? It seems like we haven't taken any steps to try to remediate what has been pointed out to you that needs to be fixed. I hear a lot of concerns from the board that I'm not sure civil penalties are CE were fixed, but I don't know if that has been asked of them and if they're interested.
Okay.
Please turn on your mic.
Okay, I'll take whatever suggestion the board gives me. And as long as it is lenient. The pharmacy has been for over a year without opening. I got medications on the shelf. I remove the expired medicines every day, and soon the shelves will remain empty. And this was a full pharmacy, so I don't know.
I mean, I think where my head is a consent agreement with all the things we were talking about. One for Mr. Tani, that's the pick, and one for the pharmacy. And I think we can include in the motion that if they don't want to sign, that we would also accept a voluntary surrender of the pharmacy permit as an option. Is that
Yes.
feasible, Miss Galvin?
Would need to hear what your terms were.
Yeah, we were kind of kicking around a bunch of stuff.
So I think probation, how long? A year?
I'm thinking 2 years probation.
Let's do the easy one. Let's do the pharmacist first.
Madam Chair, I have one other question for
Okay.
staff. You talked about the security if somebody could go over through the ceiling.
That's correct, Mr. Thornwell.
What about the walls?
The walls seem secure. It is a sort of a duplex suite where 3 of the walls are exterior walls, which did seem very secure. The main concern was the wall that shares an adjacent suite.
Well, that's why I asked that. I remember taking over a building where there had been a storage previously for controlled substances many years ago. And all there was between the two buildings was a double wall of sheetrock. And that's why I asked that.
Correct. And to be clear, a double wall of sheetrock would meet our requirements. In this situation, there were holes between the drop ceiling and the structural ceiling, significant openings.
I would have concern about double wall of sheetrock meeting requirements because all it would take is a good punch and you're right through that wall.
And just to clarify, the old pharmacy did not have what we are talking about. The new pharmacy have the requirements in the ceiling, so nobody can crawl through the ceiling into the pharmacy. It got the requirements in the wall. Nobody can break into the wall, into the pharmacy.
Okay.
Yeah, but the new pharmacist is not approved yet, so
Well,
that's gonna be
I think
process.
that's
Yeah.
irrelevant at this
Yeah.
point. So let's talk about a motion for Mr. Tani, the pick.
Should we agree that the 4 violations that were stipulated in the complaint are substantiated, I think is first, and then move from that?
Mm-hmm.
I mean, I don't think we have to substantiate it today, but
Okay.
I'm thinking 2 years probation, not allowed to be a pick within those 2 years, not a preceptor. That's for him. And about like for sure CE in law, I mean, ask him to retake the like exam is good idea, but I don't know if that will help the situation because I mean, like you are law follower or not, right? So, but I will be more in favor of like CE related to control medications, DEA rules, you know what I mean? Like 15 hours.
I'm fine either with
Yeah.
MPJE or $1,000 fine.
Yeah, and of course there is fines in addition to that.
Yeah, I mean, I think these are egregious violations
Mhm.
that have been substantiated. I think we should do the max for each violation.
Yep.
So I'll throw this out. Civil penalty of $1,000 for each violation noted, total of $4,000. License to be placed on probation for 2 years. May not precept interns, may not serve as PIC, and must petition board to lift probation at the time the permit probation is lifted, if we do that with the permit.
Anything with C.
And require passing of the MPJE.
Just a thought, should we give him an option to select either going with a fine or retake the MPJE? Either. Clearly, he's not abiding by the law.
If our
Mhm.
purpose is for him to be educated, I don't know how a fine would be another option.
I
or
don't-
equal.
I don't know that I think he's gonna learn because of the fine, but
Yeah.
I think ensuring that he understands the laws and the requirements of Arizona, to me, is more important than him paying a fine.
Yeah.
I would
To
agree with
ensure that he's safe to practice. If he doesn't understand basic requirements like a controlled substance inventory and making sure that your pharmacy is secure and those kinds of things, I worry, does he know how long a prescription is good for? Does he know when it's appropriate to dispense a controlled substance? Does he, like, things that could be of higher concern from patient safety? The fact that medications have to be stored within a controlled room, controlled temperature and monitored appropriately. He could have been dispensing adulterated drugs, and if his pharmacy was open today, because he doesn't have appropriate monitoring.
Just like another question, are you aware if he submit data to PMP? If the pharmacy submitted, did you check that?
So there was no indication of him being delinquent from the PMP for the time that he was open back in 2023.
Okay.
How do we fill it up, MPJE or C?
I could go either way, personally. I don't know what anybody else thinks.
I will
Just
go
to be
this-
clear, I think what's on the table is MPJE or civil penalty plus CE, correct?
Correct.
That's why I asked if we should get,
Ms. Galvin, is that a possibility? We don't usually give a choice in a consent agreement. Oh, for our discussion.
yeah, for our
Okay.
discussion. Yeah.
Okay.
I lean more to CE, but
He's been doing CE for over 20 years and it's not done much benefit.
and he
So-
passed the law before,
And,
so
well, he passed the MPJE 20 some odd years ago. Things have evolved.
Pretty sure we had a controlled substance inventory and you had to
That's
store
true.
drugs appropriately, but that's beside the point.
I lean toward the MPJE. I'm sorry.
Well, and I would think that he would also have to do some things to prepare because he clearly doesn't understand the laws and the rules today. So he would still have to do some education to pass.
Should we do a max attempt on the MPJE? I don't want 5 MPJEs in front of us. And retakes.
We can do whatever we want on a consent agreement.
Or do we have to, should we give him a time frame that he has to pass it? And if he doesn't pass it, then he has to appear before us again.
We could do that as well.
Because his license, he would still be able to practice on probation.
Correct.
But what if he failed the MPJE?
Let's take a stab at
Okay.
let's take a stab at a motion and then we can discuss.
Okay, I'll go. For Mr. Tani, 2-year probationary period with the terms of the probation being that he is not able to be a PIC for a period of 2 years and he must pass the MPJE within a period of 6 months. Failure to pass the MPJE within 6 months would require a appearance back before us. And he'll need to reappear prior to the lifting of his probation.
Second.
and I'm sorry, can I be a preceptor as well?
Yeah.
Right?
Yeah, that was in there.
Yep.
What about including language in there, moving to potential revocation if he doesn't pass that MPJE?
We could do that as well.
I think
Move to hearing.
yeah,
If
I
he's
think
not
Madam
able to,
Chair,
if he's not able to do it in 6 months, move to hearing.
we could do that, yes, rather than up here. Yeah.
Is there anything about not owning a pharmacy? Potentially.
You can own it.
You don't have
Not
to be a
running it.
pharmacist to own a pharmacy. He'd have to have another pick with this because he can't be a pick. So in order to open his pharmacy, he'd have to find somebody and hire and pay them to do that. Okay,
Okay.
so shall I restate it or are we good? Okay. Do I have a second?
Second.
I have a motion and a second. Any discussion?
And if he does not sign the consent agreement, then go to formal hearing?
Yes. Mr. Thorwald, you're in agreement?
Roll call, Madam Chair.
Please.
Mr. Braswell.
Aye.
Mr. Thorwald.
Aye.
Ms. Snare.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Lehan.
Aye.
Mr. Dang.
Aye.
Mr. Nassif.
Aye.
And Mr. Anderson.
Aye.
Ayes have it.
Thank you. In the matter of the pharmacy permit,
I still like the idea of a consultant before they're allowed to
Yeah.
reopen. Destruction of all the medications that we don't know their storage conditions.
Well, we're forcing him to, because he can't be the PIC, to hire a PIC. So there may not be a need for a consultant because there's going to be somebody else in charge.
That's true. Anyone but the other person.
Correct. Well, no, but
The other
there's
person
somebody
that he
that's
mentioned.
working per
current
diem for
consultant.
him that is clearly ineffective as well.
I think the challenge is when you put in another PIC, they're not equipped to write us a report so that we're confident that everything was resolved. And that's where the consultant comes in.
Consultant is fine.
But there's 6 violations noted for them. And we didn't do any civil penalties for the pharmacist. I think we need to clearly indicate that this is unacceptable and the permit should be paying civil penalties if we didn't assign it to the pharmacist.
I agree.
Although I think that the things that we're considering for the permit are definitely are putting the notice out there that it's not acceptable.
and there will be a consent agreement that details all the findings of fact that these were inappropriate actions. I don't personally think a fine is necessary, but
So
I
the
don't
permit
either.
is, the permit will be on probation for
that's what we've been talking about.
Yeah, I can try to make a motion for the permit for a 2-year probation, destruction of the medications, hire a consultant, and reinspection at their cost at 6 months after opening.
Just add appropriate destruction of medications, because also there's a rules you need to follow.
Yeah.
Yeah.
I added
Yeah, this is,
destruction of
yeah,
medications.
yeah, like,
And if they don't sign it,
Yeah.
move to hearing, or will we also accept a voluntary surrender as an option? Is that good?
I'll add that. I add that to my motion.
Second.
Real quick. So they'll already have an opening inspection again, correct? If they were to open, and then we want a 6-month one after that as well. Yes?
And if they failed to pass the opening inspection?
We wouldn't issue a permit without a past opening inspection, right? Like we just don't, it never comes before us. At some point, it'll just time out, right?
I don't even think we're gonna entertain an opening inspection until this consultant gives us a thumbs up that everything is resolved.
The permit is on administrative hold at this time. So I'm just thinking how you bring in a consultant in essentially an unpermitted facility that's not.
Consultants are typically pharmacists also. They're licensed with us. And so if they bring in that licensed pharmacist, they're allowed to be in that pharmacy.
No, I'm not, that's not my point. My point is, preparing the pharmacy for opening is what you're thinking instead of
Yes.
an operational.
Correct.
Mm.
Also, I have another concern that maybe I should add. If they don't open within a certain amount of time, maybe close the permit.
Don't we have a requirement in the rules
That's
for that
already a
anyway?
statute, yeah.
Okay.
That's already in a statute that if it gives them
9
9
months.
months to open a pharmacy, give another 9 months extension upon request.
Okay.
So in theory, they have about 18 months to get operational, otherwise we close it.
They're about halfway through that already. So we really probably should also already have a request to extend that, even though
And do we need to ask for certificate of destruction for the medication, like to assure they did? Because usually if they use third party, they can't give them
If they
certificate.
submit their drugs for destruction, there's usually documentation.
Documentation,
and
so we
there's-
need to ask for that, right?
There's permitted locations that destroy medications. That's who they would have to go
Okay.
to.
Is that something they would look for in the opening inspection because of the board, this discussion that we're having today? Okay, if I need to include it in my motion, I will, but I think it's understood now.
There's one wrinkle, you know, if the reverse distributor wants to see their permit, it may not match up with where it's coming from. And so we have to keep that in mind. I'm not sure if that'll be checked by the reverse distributor, but
Yeah, we can work with that reverse
Yeah.
distributor.
I guess we can get involved and let them know, you know, it's okay.
Within what period of time do you want the consultant hired and the destruction of the medications to occur?
Soon.
Well, their
And
permit has a time on it. So it would all have to coordinate along with the permit, right? It's going to close or they're going to get it done.
What about the not making sure that they don't use the existing consultant?
I know, I was gonna say approved, consultant approved by the board, but I don't know if we've ever done that before.
You know, I don't think the existing consultant's in a position to write us a report. So,
I think we should just give them the liberty of choosing
a professional
whoever-
that
a
knows how
professional
to open a
consultant.
pharmacy. Exactly.
and perhaps if they don't know who that is, the board staff
We
or the
can direct
inspectors
them.
could provide them some guidance on
Yep.
where maybe to go with that.
Mhm.
I would recommend putting some deadlines and perhaps 45 days or
I
30
think that
days
would
to
be-
destroy the medication, 45 days
Yeah.
to hire a new consultant.
I will go with 1 month, 30 days
Yep.
For both.
Let's go with 30 days. for them.
for both. It takes time to make contract and contact
That's an
people.
appropriate time frame, everyone.
Yeah,
agrees.
45
Mhm.
days is too long. I believe 30 days is.
Mhm.
Okay.
Just to make
Yeah.
sure that those medications stay where they are. You're not moving them. You're not giving to public till it's destroyed.
Mhm.
Okay,
Would that, I'm sorry, I'm just trying to make sure that we get this clear. Would that order or consent agreement can include a provision that if they fail to show proof of the medication destruction within 30 days or fail to provide us proof of a consultant within 30 days, move to formal hearing? So if any one of those provisions of the consent agreement are not met, do we go to formal hearing?
At minimum, come back before the board, but
Yeah, and if we do that, then we're just kind of kicking the can down the road. So I think we
Move to
have to be a
formal
little
hearing.
more aggressive in
Hearing.
that
I
respect.
would recommend moving to formal hearing so we can take action.
Mhm.
But that will be for the permit, not for the
Yeah, we're talking about
the-
permit
the
holder.
The
right now.
permit.
Madam Chair, if I can reinstate or restate everything that you mentioned. So consultant, hire consultant within 30 days. 2-year probation. Destroy medications within 30 days. Re-inspection after the opening inspection at the expense of the permit holder. 6 months after.
Mhm.
And if not signed, go to formal hearing. If consultant not hired or meds not destroyed, go to formal hearing.
that's my motion.
And that was a 2-year probation?
2-year probation, yes.
I second that. Oh. Okay.
I have a motion and a second. Any further discussion,
Roll call, Madam Chair.
please?
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
And Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you very much. Thank you, Mr. Tanya, for your time.
Madam Chair, may add something to this case. Just a thought, since his son is an intern, should we open a complaint for the intern? What I have in my mind is non-disciplinary CE on
He's not named in the complaint.
That's what we're gonna open a
Yeah,
complaint.
I believe he works for Walmart. He said he doesn't work for this pharmacy. He said he's an intern for Walmart.
But Mr. Jacobson said that he's seen him there at
Yeah.
the Gilbert Pharmacy. So are you working for Gilbert Pharmacy as well?
So I primarily work for Walmart, and I help out maybe for a few weeks in the summer at my dad's pharmacy, but primarily for Walmart.
I think this is probably a pretty big lesson for him, and he was being directed by another licensed pharmacist, which is the purpose of intern supervision. I don't know that I think we need to open a complaint, although I hope you're hearing us today that these are extreme concerns, but if anybody else feels differently, that's
No, I believe he learned his lesson, and then the message got the message. I'm fine with.
I'm fine too. I don't see that a
Okay.
complaint needs to be opened.
Just a thought. Thank you.
thanks for bringing it up.
Yeah, I got a question.
The staff can reach out to you after the meeting. At this point, it's we're past the discussion point. We've made our decision.
Oh, you did? Okay.
Yes.
Okay.
The staff
All
will
right.
reach out to you.
Okay.
Dr. Gandhi, can maybe one of the compliance officers speak with them in the hall?
Certainly.
Okay.
Right, we're gonna move on to,
Madam Chair, could we have a short break?
sure. How long would you like? 5 minutes, 10 minutes?
5 minutes is adequate.
All right, let's come back at 11:25.
Welcome back. We will resume with tab 25F. This is complaint number 24-0127. Respondent Walgreens. And that Mr. Brandon Malachi, Jeffrey Pensaka, Michelle Orez Salazar, and Walgreens. And we've got Mr. Wagner for the board. Would we please have the respondents introduce themselves, please, for the record?
Hello, I'm Brandon Malicki.
My name is Michelle Morales. Susan Trujillo from Corals representing Walgreens.
And Jeffrey Pasega, pharmacist.
And we also have Mike Simcoe from Walgreens available online.
Welcome, thank you. And Mr. Wagner, would you please introduce yourself and provide a brief summary for us?
I'd be happy to. Dennis Wagner, Compliance Officer. An electronic prescription was received at the pharmacy for Bicillin LA with a quantity of 4 mLs or 1 syringe, with directions of inject 4 mLs into the muscle once for 1 dose. The complainant picked up the prescription and returned to his provider for administration. After administering the single dose, the practitioner instructed the complainant to return the extra 9 syringes to the pharmacy for disposal. Pictures provided by the complainant confirmed that the label was placed on a box of 10 syringes. A review of the counseling logs found no documentation of counseling acceptance or refusal. Written statements from the pharmacy staff indicated that the patient leaflet did not indicate new to therapy or NTT. Since the NTT indicator was not on the leaflet, the prescription number was omitted from the counseling log, and the patient was only asked if they had any questions for the pharmacist. An investigation by the company was ongoing for the missing NTT designation. No additional information regarding that information or investigation has been received.
Thank you, Mr. Wagner. And Ms. Trujillo, would you like to make a statement for Walgreens?
Yes, please. So the pharmacists and the pharmacy technicians also have brief statements, but first I wanted to update you on Walgreens' investigation into the NTT or new to therapy issue. That's printed on the patient leaflet up in the top corner, and that indicates to the pharmacy staff that this is a new to therapy prescription where counseling is required. Early in the investigation process, there was an assumption that NTT didn't print on the leaflet because it didn't appear when the pharmacy reprinted that pamphlet after as part of this investigation. But since then, Walgreens investigated the issue and found that NTT does not appear on reprints of those leaflets. The software is programmed with the assumption that the original prescription has already been dispensed so that NTT doesn't need to appear on the reprints. So for this reason, when the leaflet was reprinted during the investigation, NTT didn't appear. However, the software is correctly programmed to print NTT on those prescription leaflets when required, and there's no reason to believe it didn't print on this original patient leaflet. As a result of this investigation, Walgreens is reprogramming the software so that NTT appears on reprints of a patient leaflet to avoid any confusion like this in the future. Now we'll turn to the pharmacist statement. Brandon, you'll start.
Morning, ladies and gentlemen. My name is Brandon Malicki.
Mr. Malicki, could you?
Good morning, ladies and gentlemen. My name is Brandon Malicki, and I've been a pharmacist for 14 years, 8 of those in Arizona, 6 in Nevada. And over those 14 years, I have managed 7 different locations, with this being the first time I've been summoned to the board. I do accept responsibility for my fault in the matter, and I am here today to address that error that was made. I'm fully committed to learning and evolving from this experience to ensure that my practice is held to the highest of standards. Since the time of this occurrence, I have personally taken 3 CE courses on error prevention, quality assurance, and reporting. I've educated each member of my team as far as counseling on the logbooks and notifying the pharmacist of every time there is a new prescription to be counseled on. Especially in regards to this event specifically, with the NTT being on the leaflet and my technician not alerting the pharmacist about this, I do want to apologize to to Jeff. He does his job extremely well. He is a floater at my location. He comes to my store about twice a week, once a week. And I know he does love talking, counseling to all his patients. So I do apologize to you because that's his thing. He was in the drive-through when this was happening, already talking to another patient about their prescriptions. And if he would have known that this was leaving the pharmacy without his knowledge, I know that would have troubled him because that's one thing that all my technicians say he likes to do is talk to our patients, especially about the medications. I do apologize to you about that. Thank you for the opportunity to speak today. Any questions you have, I'm willing to answer.
Thanks, Brandon. Jeffrey?
So as the pharmacist of record, I am fully aware of my responsibility to make sure that proper counseling and documentation is fulfilled. I accept full responsibility for that part of my job. I do realize that there are times where it may be difficult to make sure that that's done the way it's supposed to be done, especially when I'm busy and the patient is in a hurry and wants to leave and has made, the statement that I don't need to be counseled. I've already been administered this prescription before, but still it is my responsibility to ensure that's properly done. And as from this point on, I have been working with my technicians to ensure that they're using proper verbiage to ensure that patients are being directed to the consultation window as opposed to just say, do you have any questions for the pharmacist? And even to the point where it's, if I hear that, I go, was that refill to my technicians? Because that's the only time that they're permitted to actually ask that type of question.
Thank you. Michelle?
Hi. My recollection of that day is limited. However, it's clear that if the medication was filled incorrectly, since the occurrence, I've slowed down, double checked my work, and asked the pharmacist if I have any questions. Thank you.
We're happy to answer any questions you may have.
Thank you. The floor is open for questions.
Yes, sir. I have a question for Jeffrey. So you're the final checker for this prescription, right, Jeffrey? You're the final checker.
Correct.
Correct, I was.
Okay.
I was the final checker of the product.
Okay. So, in my opinion, as the pharmacist, whether the leaflet has NTT printed or not, when you're dispensing an injectable medication, it is our job to make sure that the patient understands how to administer it, or at least give them guidance on, or referral to another medical professional to administer the medication. This is a very expensive medication too. And I've never seen any, even in hospital or retail setting, I've never seen any prescription that calls for 10 syringes of bicillin. Never, ever, ever. So two things, in my opinion, that had fallen through the cracks. Number one, if at any given point in time, when you see 10 syringes of bicillin, that alone should raise a red flag in your mind. Number two, is this an injectable medication? You have to make sure the patient knows how to either self-administer or have another medical professional administer their medication. So both of those alone should convince you to meet with the patient, provide direct patient counseling to the patient. So just my thought on that one.
And just to clarify kind of who was involved in what in the process. So it was Brandon who was the pharmacist that verified the prescription.
Mm-hmm.
He wasn't there when it was dispensed. It's that Jeffrey was there at the pharmacy when it was dispensed. So, Brandon is the one responsible in terms of the fill, but in terms of who was present when it was handed to the patient, that was
Jeffrey.
But
Right, but
Jeffrey wasn't informed that it needed to be counseled.
right. It sounds like the patient had said to the pharmacy staff, "Oh, this is being administered in the office. I'm fine," and had left the pharmacy. Certainly, NTT was on there. Mandatory counseling was required, and that information wasn't on the log. But just wanted to make sure that you knew kind of who was on first here.
So Jeffrey, have you taken any CE after the occurrence of this incident?
I have not taken CE as of yet on this regarding this incident. I was kind of waiting to see what the direction the board was going to take on this, basically because I understand it's more of my involvement was had to do with the lack of the counseling being documented correctly, so I didn't know which direction the CE was going to go.
Yeah. Yes, I have.
Was the patient administered more than one syringe?
Based on what we've heard back, they were not. They were only administered one syringe by the office.
Right, I believe it was the practitioner that made the complaint or advised the complaint to make a complaint and caught it at that point.
So I recognize it's a really unusual drug. Have any of you pharmacists ever seen that or dispensed that before?
I've worked in the retail setting for 14 years. I've managed locations from 150 prescriptions a day to 900 prescriptions a day. This is the first time I've ever dispensed that the Bicillin shot.
And that was the reason I was asking, because I'm in the same position. I've seen it one time ever come through.
Typically, our scanners are very good at if you get a box and you have to take one out, they're good at tracking that this particular drug, because I do not dispense it a lot, the scan was overridden. I saw that on my screen. I didn't open the box. I should have. And I had the label on it.
Well, and that was part of my other question. Because it is such an unusual drug, does Walgreens have any additional steps in there to help to know this? Sometimes because it's an unusual drug, there won't be because it's not seen very often. But in other cases, because it'll say, double check quantity or something along those lines. I didn't know if that was any sort of pop-up for you for safety, or if you recall any of that.
If a scan is overridden, that pop-up comes onto my screen. I verified the NDC number.
But
What
not
I've
like a
seen-
safety additional.
Yeah, I'm not aware of any, additional specific information related to this drug, that a different pop-up is given. Mike Simcoe, do you have any information on that? Oh, Mike, I don't know that we can hear you.
While we're waiting for him to sort out the audio, Mr. Maliki, just a follow-up question to Dr. Lehan. The fact that it's so rare, did you have to order this specially and the box of 10 came into the pharmacy, or did you have it in stock?
No, we did have to order it. It came in the next day.
Okay.
Well, these kind of injectable products with strange volumes are always tricky because, like Lovenox, for example, a 1 is not one syringe. One syringe is 4. I can definitely see dispensing 4 syringes on accident. 10 seems a little harder to wrap my brain around, but I understand that these kind of drugs have difficult quantities associated with them.
And I believe Mr. Simcoe, is it Simcoe?
Yes. Can you hear me now?
Yes, we can.
Yeah, great. Thank you. Back to the question. If the scan is overridden by the technician, we have a scan that matches barcode on the prescription label. It's supposed to match the barcode of the product. In this case, it didn't because she scanned the box instead of the individual syringe, which the difference in the NDC numbers, which is the part of the barcode scan, would have been the last 2 digits, which is the quantity. So she overrode the scan. The pharmacist doing product review is alerted that the scan was overridden, and that's usually directs them to a closer look, or just be aware of the fact that the scans didn't match up or the scans weren't done.
So is the single syringe barcode that's within this box of 10, is that scannable? Had she have scanned the single syringe, is that configured correctly so that
we didn't check that since we gave them the entire box, but that's what should have happened.
that would be a good follow-up QA check to make sure
Sure.
that is in your system?
Yep.
Yeah, I feel oftentimes those kinds of things aren't as easy to scan when you break open and do a single shot like a Lovenox injection versus the box or whatnot for accuracy scans. So I'm not sure, for me, that plays a lot of bearing into this part right now for me.
So I'm sorry. So Michelle, what's your involvement in the? I mean, are you the one who?
I'm the one who filled the medication and I overrode it because I tried to scan the 2D barcode, which is what we've been taught, and it didn't work. So I went into IC Plus to reprint the label and I handed it off to the pharmacist.
Okay, and are you the technician who sold it to the patient? No.
That's not my store. I only help as needed, so I was not
Okay.
there when it got sold.
All right.
Ms. Salazar, you were unable to scan the barcode on the package or on the individual
The
syringe?
whole box, the
Okay.
2D barcode.
So what? I mean, unless if anyone has any questions, but I have a motion for Jeff or Jeffrey, right? So I believe from my perspective is dismiss or letter of concern because he's not been notified by technician to go to the window, otherwise he would, right? And I believe the system failed him. He did not fail the system. So for him, to me, it's dismiss. For Brandon and Michelle will be 3 hours CE, non-disciplinary for error prevention and patient safety. And since Walgreen already addressed the issue and they fixed it, or I will dismiss the permit holder as well.
I'll second that.
All right, we have a
Thanks,
motion.
Lionel.
We have a motion and a second. Any further discussion?
Just to be clear, non-disciplinary.
So non-disciplinary 3 hours CE, error prevention or patient safety, whatever available for them.
So
All three.
Oh, for Michelle and Brandon.
So Mr. Malicki, you had commented that you had already taken additional CE.
Yeah, so I will give him credit for what he's done after the board staff approve.
Very good.
I would be in favor of having Jeffrey, Mr. Pensaca complete 3 hours of CE, non-disciplinary.
Well, I agree with Mr. Alnasafe because he wasn't notified. And we've never, and to my recollection, held someone accountable for something they weren't aware of.
I mean, like he could be in the restroom or bathroom, and who knows, right?
But
Like, and the technician.
Like what I had alluded to earlier, when you're dispensing injectable medication, just always good.
You don't know that you're supposed to give counsel. You can be over here doing.
He wasn't aware this medication is been dispensed. Nothing, just like people.
After the other, you can counsel. I mean, you can be filling over here and they come in 2 days later. You know what I mean? Like, you can't hold someone responsible if they're not directly part of the process
Okay.
or aware that they have to do
And
that.
he didn't fill the prescription, so he didn't know there's like a box of
He wasn't.
LA and will call.
He was just
somewhere.
helping the store floater. He's not even aware there is by some LA like in process. He just.
Okay.
Any further discussion before we go for a vote?
Is there a feeling that we need to take this motion in pieces?
Yeah. So for Mr. Maliki.
Okay, I'm just asking if there's.
I think.
Okay.
All right, since it's non-disciplinary, we can do a voice vote. All right, all in favor, please say aye.
Aye.
Any opposed? All right, motion carries. Thank you very much.
Thank you.
Thank you.
All right, our next case is tab 25G. This is complaint 24-0224, respondent Nora Strom, technician.
Yes, I'm here.
Thank you, Ms. Strom. Would you please introduce yourself for the board?
My name is Nora Novastrom.
Thank you. We have Ms. Mitchell coming to the front. Just one moment. Welcome, Ms. Mitchell. Would you please give a summary for the board?
Thank you, of course. Ugh. How am I out of breath? I didn't walk that far. Okay. On April 18th, 2024, the board office received a notice from the Department of Public Safety stating that Nora Strom's fingerprint clearance card had been suspended. The notice indicated that Ms. Strom had been arrested and/or fingerprinted for shoplifting. After receiving the notice, staff searched the Mesa Municipal Court website for charges filed against Ms. Strom. The website indicated that she had been charged with shoplifting dash concealment on or about April 8th of 2024. Staff allowed Ms. Strom 10 business days from her arraignment to report the charge, but she did not report the charge to board staff. In her response to this complaint, Ms. Strom stated that she was cited for shoplifting after she tried to exit the Hobby Lobby without paying for craft items that she had concealed in her tote bag. She also stated that she accepted a plea agreement that required her to attend a shoplifting diversion class. She indicated that if she completed the course and did not reoffend, the charge would be dismissed. In response to the allegation of failing to report a charge within 10 working days, Ms. Strom indicated that she was not charged with the felony and did not believe that the shoplifting charge was relevant to patient safety. Ms. Strom provided a copy of her plea agreement and documentation of her completion of the shoplifting program through Prodigy Healthcare. She also provided documentation of the dismissal of her case.
Thank you, Ms. Mitchell. Ms. Strom, would you like to make a statement?
So to my understanding, there was some questions about what was taken and how much it was valued at when this case number was last heard. So it was about, I would say 10 or so smaller items, these little vials of like craft beads. They were approximately $6 each for a total of $60. Everything was returned to the store and there was no restitution required. So as of May 28th, the charge was dismissed and the case it's done.
Before we move into, would you like to make a comment on why you did not fail or why you failed to notify the board of this charge?
So I was under the impression I take responsibility because I didn't read the website closely enough. What I read was that it was mandatory reporting if it was a felony or if it was related to patient safety. I did unfortunately not read beyond that, but it was I was under the impression that this would not rise to like affecting patient safety.
Thank you very much. We'll open the floor for any questions.
I thought I read someone here that the value was $165. Yeah, on page 4703. You paid back.
Me. This is just from my recollection.
Well, it's a big difference, 66 or 165.
I understand. That's
oh, is that how much your program was?
No. No,
Oh,
I was referring to the total. I'm sorry. I was under the impression that what I was remembering was that it was about 10 items. If it was more than that, I apologize for the mishap information there, but whatever it says from the court is obviously correct.
I'm sorry. You know what, my error, that was how much you paid for your class. That was my error. Sorry about that.
Okay.
So Ms. Strom, I've got a question. So we were notified by the Department of that your fingerprint clearance card had been suspended. What is the status of your fingerprint clearance card today?
So it is still suspended. It is entirely my fault. I was so caught up in my case with the Arizona Board of Pharmacy that the fingerprint case completely slipped my mind. I currently have the documents, like the letter that they sent me with the contact number on there. I called them yesterday and they were not available. I will definitely try calling them today as well to get that sorted out.
So you're seeking a good cause exception from the fingerprint clearance
yes.
Fingerprint Bureau?
Yes.
So I just want to say, you don't see the correlation between your job and this, and I do, because you're in a position in a pharmacy where diversion is a real risk, and theft is all that I know so far about you, is that you've shoplifted. So how can we assure that you're not going to be doing that in a pharmacy?
So I would never do anything to risk my job. I am very dependent on it, as are most Americans. It provides me healthcare. I can pay my bills and my rent and my car payments. If I lose that, then I will have no way at the moment to make ends meet. It was a lapse in judgment. It was a really bad mistake. And when I first got the notification from Board of Pharmacy about the failure to report, that is what I read at the time from my statement earlier about like not reading beyond that. Since then, I have read the whole page on like every crime that counts towards this, which is practically every crime, which is understandable. I have watched so many of these the meeting videos and heard so many cases, and I absolutely understand that it is a big concern, but I really want to underline that I would never do this again. I have absolutely learned my lesson. It has been so challenging and embarrassing in my personal and professional life that I really hope that I can just underline how much that I would never do this again.
Thank you, Ms. Strom.
Ms. Strom, the question I have for you is your current employer aware of the charge?
No, they are not.
How long have you worked at the pharmacy that you currently work at?
Since February of this year, I'm sorry.
Your answer earlier was you said that you would never do anything to risk your job when you were asked about the concern from taking something from the pharmacy, but you did risk your job. And I just want you to know that.
Yes, I am very much aware of that. Thank you.
Any further questions?
I agree with Ms. Snare about like concern the type of offense and the job. And I believe notify employer, that's what assure us that somebody is supervising her, so she will not divert any drugs from the pharmacy. Otherwise, with this type of like offense or crimes, is always concern me about having somebody work in a retail setting or any pharmacy setting, doesn't need to be community, and the employer not aware of these charges.
Okay, I can definitely notify my employer if that is required.
Chairman Anderson, I would like to make a motion to impose this $250 fine to the licensee.
Second.
Is that non-disciplinary, Kevin?
Yes, sir.
So what about any discussion on ensuring that the fingerprint clearance card is issued? Are people concerned that she may not get that reissued?
This will be like, maybe we can do like another motion after his motion pass about the fingerprint and about notifying the employer.
Or should we combine all together in one motion?
Let's just.
Ms. Galvin, do you have a
Galvin, yeah.
recommendation?
Without, I'm unsure of the basis that you would require her to notify her current employer without finding that a violation had occurred. Here you're imposing a non-disciplinary order for civil penalties, suggesting that it doesn't rise to a disciplinary level. Typically, a requirement to report to your employer is part of a term of probation, is how we've typically done that in the past. And she did complete a diversion program
Mhm.
and the case was, the matter was dismissed.
This meeting is also on public record, so they very well may know that she
Mhm.
has this incident too now.
What about the good exception? We can ask for that. I think we've done that before.
How do we bundle that good exception fingerprint clearance card in with a non-disciplinary civil penalty?
You know, you could require her to submit proof to you, if and when she receives the good cause exception. They're required to have go ahead,
They're required to have it upon filling out the application.
but not maintain it. Okay,
Doesn't state that they have to retain
But
it.
in the last board meeting, we asked someone to give their,
We can request it, but I think it may have to be done on a consent agreement or something to file a good cause exception.
ask her for an update. She indicated that she is going to seek a good cause exception. So ask her to provide the board with, an update on the outcome of that request.
that would make it disciplinary.
No,
No.
no,
Okay.
no.
And I
Sure.
believe, Mr. Anderson, I believe, Ms. Galvin, that process is fairly quick. So is there a time period we should ask her to let us know? I think 4 weeks may be adequate if she's already filed a good cause exception.
If it's important for you to get that, do you want to table it to the next meeting and have her provide that to you?
It may make sense. I don't, what are your thoughts, Ms. Mitchell?
You're gonna make her do it anyway.
There's nothing tied to it unless you table it, so.
Yeah, that's the only thing. And you know, having that clearance card would then be able, we would be able to track her activity for at least 6 years or so. So if she does get caught shoplifting or any other, we would be notified.
Okay.
I like that.
Yes, then I would rescind my motion and make a motion to table this case till the next meeting.
That gives her 2 months to get the good cause exception. And that, from my understanding, is adequate time.
I rescind my second.
All right,
And my
so
motion is-
Dr. Dang, is a motion to table until the October meeting. Is there a second?
Second.
3 seconds.
All right, all in favor, please say aye.
Aye.
Any opposed? All right, and the
Does
complaint,
Ms. Strom understand? Just want to make sure she understands what's expected.
sure, Ms. Strom, do you understand that we are asking you to seek a good cause exception through the Department of Fingerprinting from the state of Arizona, and that you must present that good cause exception at our next meeting in October?
Yes, I understand.
All right, thank you very much.
Thank you.
Ms. Walmsley, we're ready for you.
Seeing that we're at noon, however, we do not really have very much left on the agenda. I think we probably have about an hour's worth, I would guess, of stuff left. I would suggest that we continue going rather than making the public come back, but I am certainly welcome to the thoughts of the group.
I like that.
Huh? Keep
I
going?
like it. Keep going.
Keep going. Any objections? Okay, we're gonna power on. Let's go to 25H, complaint number 24-0087.
And I will be recused due to my employer.
Thank you. Getting this fired back up. This is for Krista Noel Ellis. Is Miss Ellis present? Ms. Mitchell, do you want to give us a summary?
Certainly. At its December 2023 meeting, the board directed staff to open a complaint if they received a notice from the Department of Public Safety indicating that a technician, trainee, and registrant had been denied a fingerprint clearance card for a reportable offense that occurred within the last 4 years. On February 5th, 2024, the board office received a notice from DPS stating that Krista Noel Ellis had been denied a fingerprint clearance card as she was arrested and or fingerprinted for aggravated assault, deadly weapon / dangerous instrument involving domestic violence, and disorderly conduct, weapon / instrument involving domestic violence on or about May 22nd, 2021. After receiving the notice, staff searched for charges matching those listed in the DPS notice, and staff found that Ms. Ellis had been charged with the aforementioned offenses on or about June 9th, 2021. The record indicated that the case had been dismissed with prejudice. In her response to this complaint, Ms. Ellis indicated that she was arrested after she pointed a gun at her ex-husband after an argument. Ms. Ellis provided a letter from the Office of the Legal Advocate in Cochise County. The letter stated that the felony charge filed against her had been dismissed with prejudice after she completed the Cochise County Grace Program. She also provided a letter detailing the requirements she had to complete as part of the program and the police report relating to her arrest. All of the documents are included in the board's materials.
Thank you, Ms. Mitchell. Board members, questions or discussion?
Do we have any indication that she plans to be part of this process today?
She was notified, but I don't think I received anything from her.
I think it would be appropriate to proceed to a hearing and accept a voluntary surrender as well, if they determine to go that direction.
Say your motion. I agree. Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. 25I, Martha Karina Shepherd. Is Ms. Shepherd present? Ms. Mitchell, if you could give us a summary.
On November 9th, 2023, the Department of Public Safety informed the board that Martha Shepherd's fingerprint clearance card had been suspended. The notice indicated that Ms. Shepherd had been arrested and or fingerprinted for misdemeanor assault involving domestic violence. After receiving the notice, staff searched the internet for charges matching those referenced in the notice, and the Tempe Municipal Court website indicated that Ms. Shepherd had been charged with assault-injury on or about November 6, 2023. Staff allowed Ms. Shepherd 10 working days to notify the board of her charge. She did not do so. In her response to this complaint, Ms. Shepherd stated that she was arrested after she got into an argument with her husband and it became physical. She stated that she had to defend herself and she scratched him. Ms. Shepherd also stated that she had contacted the Tempe Police Department for a copy of the police report related to her charge and was told the wait time was 7 weeks. Staff allowed Ms. Shepherd time to receive the report and followed up with her by email. She responded by stating, "I had already sent." When staff asked when she sent the report, Ms. Shepherd did not respond. Failing to receive a response, staff started to prepare this case for consideration by the board. While doing so, staff discovered that Ms. Shepherd had been charged with assault-injury, interfering with judicial proceedings and criminal damage on or about December 23rd, 2023. Staff sent an email to Ms. Shepherd requesting an explanation of the new charges and the police report for the second incident. She did not respond. According to the Tempe Municipal Court website, Ms. Shepherd pled guilty to the November 2023 assault charge on or about May 28, 2024, and the charges filed in December 2023 were dismissed on the same day. Ms. Shepherd disclosed a 2022 assault charge on her application for licensure. The charge was dismissed due to insufficient evidence of the defendant's guilt.
Thank you, Ms. Mitchell. Questions or discussion?
Do we know the status of the fingerprint clearance card today?
It's not valid.
What was the last part that you said? It was dismissed because of insufficient evidence? I missed the last part.
Oh, yes. Excuse me. The one she disclosed on her application was dismissed due to insufficient evidence.
And then she's had 2 subsequent charges that were not disclosed.
Correct.
Does it show on the board profile if she's actively working? Does it say who her employer is?
Madam Chair, it looks like Ms. Shepherd is online.
Ms. Shepherd, are you present?
Cam, you do see her?
I do. I requested her to unmute, but she doesn't look like she's responding.
We want to go to the next one and we can come back to her and somebody can call her.
Sounds good.
Madam
Madam
President,
Yeah.
if I may we return to 25H, Miss Ellis, the one that you moved to formal hearing? I'm seeking clarification and perhaps need to provide you legal advice in executive session. I'm not clear with respect to the violations because this is a trainee application. The event took place in May of 21, dismissed in August of 2022, and she did not apply or become registered until January of 2024. There is no question on the registrant's application about criminal history because of the statute. So it appears that she was not required to report this. And it has been dismissed. So there's no conviction out there because she completed a diversion program. So I'm not sure what the violation would be. And we need to ensure that we have adequate evidence and allegations of violations of law if we go to formal hearing.
But she doesn't have a valid fingerprint clearance card is what what the discussion was.
Yeah, as a technician trainee applicant, she doesn't need a fingerprint clearance card.
I think she has a technician trainee registration already.
She does now.
Okay.
But at the time of the events and at the time that she would have been required to report, she was not registered. So there would have been no requirement to report.
So there's no violation?
I'm struggling, but if
Okay.
someone can articulate it for me, Seth, I'd like to hear if you have a different opinion.
I agree. I'm not seeing a specific violation, but if the board members that are pushing this forward have an indication of what you feel the violation is, we can certainly look at it.
The technician trainee registration has been very different since, we changed this, since the statutes were changed. So there's not as much background information that they are required to provide.
So is it likely that she applied for a fingerprint clearance card to become a licensed technician, or we don't know
I
why?
don't know.
According to the narrative that I recall, she's going to respiratory therapy school. So she may be finishing her respiratory therapy program and may need a fingerprint
I do
clearance card
recall
for
that, yeah, I do
to be an
recall
RT.
But I think the reason it came to us, Ms. Galvin, is because we were made aware because she held a license, because she sought the fingerprint clearance card, and then it was denied. I think that was reported to us from DPS, correct? Which those automatically trigger a potential appearance before us to determine if there is any conduct that we would be concerned with.
Correct.
So I guess based on the type of charges, do we have any concerns? I guess should really be the discussion with her holding a trainee license at this point, because there wasn't a failure to report on her part.
There was not, and there is no conviction at this time because she completed the diversion.
I would be comfortable with removing the motion and dismissing the complaint. Based on what you're saying.
That's your motion?
Sure.
Yeah, I second. Let's
Hang-
pause.
Hold, please. Do we need to take a brief recess?
I think that is probably advisable.
5 or 10 minutes, guys, do you need? 7 minutes? Okay, we'll take a brief recess for 7 minutes.
Madam Chair, I think we're ready to proceed.
Excellent, Dr. Gandhi. Do we have a recommendation?
Go ahead. Oh, the previous recommendation still stands in that we believe there is a lack of legal justification to move case 24-0087 forward, given the fact that she's an applicant has a registration, the timeline of when the events occurred, the fact that she was not required to disclose, and we have no conviction of a felony.
I would make a motion to rescind the prior motion and
Second.
to dismiss the complaint. I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none.
Thank you.
Motion carries. Thank you, Ms. Galvin, for keeping us honest. Did Ms. Shepherd, were we able to get a hold of her? Ms. Shepherd, are you online?
Yes, ma'am.
Thank you so much. Ms. Shepherd, Ms. Mitchell gave a summary of your complaint. Would you like to address the board and provide any opening comments before we proceed with questions for you?
I do. Unfortunately, I was struggling with my sickness of alcoholism, and I did some stuff I normally wouldn't have done. And I am in intensive outpatient treatment. I go to meetings.
Just
Shepherd, hang on one second.
I'm concerned that we're discussing confidential health information.
Okay.
If you want to tell her that she's not obligated to discuss any diagnosis on the record.
Yes, Ms. Shepherd, you're not obligated to discuss your diagnosis on the record in terms of your personal health information. If you want to speak about it in general terms, that would be fine. If you want to get into the details of your health information, we can go into a closed session where only the board members are present. This meeting is being streamed and there are a number of people in the audience as well, just for your knowledge.
Gotcha.
Do you feel that it's relevant for us to discuss your medical information?
Yeah, only to take into account that that it wasn't my person. That it wasn't in my character.
So is it fair to say that you're undergoing treatment for some type of substance use disorder at this point?
Absolutely.
That's good enough?
That is good enough, and does that raise a concern with the board?
Yes.
Whether she's fit to practice.
Thank you, Ms. Shepherd.
Thank you.
Need an executive session with her to discuss the extent of that condition and treatment.
I make that motion
Second.
And for legal advice if
and for
necessary.
legal advice if necessary.
Second.
All those in favor?
Aye.
Ms. Shepherd,
Yes. Oh, it looks like you're muted.
Okay, welcome back. Board members, any additional questions for this? For Ms. Shepherd in open session? Thoughts on a motion?
An interim order for suspension and substance use evaluation to include a potential monitoring contract. Whatever the evaluator recommends.
Yeah. This would be a consent agreement where she would agree to undergo an evaluation and interim monitoring contract with a period of suspension.
Okay, I'll modify that to offer a consent agreement for suspension, to include substance use evaluation, to include a monitoring contract as designed by the evaluator, and must appear before the board prior to the suspension or to request lifting of the suspension.
Madam Chair, before we ask for a second, may I ask Ms. Galvin, Mr. Hargraves a question?
Yes.
I know in a prior case discussion, we talked about a fingerprint clearance card and filling out a good cause exception. Is that something we should think about here as well?
I do think that that could be a term that she should pursue her fingerprint clearance card and the good cause exception.
Would that be included in the consent agreement?
We can add that, yes.
I'll modify my motion to include that.
Do I have a second?
Second.
It would be pertinent to the evaluation, I think. Dr. Gandhi, roll call.
Mr. Braswell?
Aye.
Mr. Thorwald?
Aye.
Ms. Snare?
Aye.
Ms. Davis?
Aye.
Ms. Walmsley?
Aye.
Ms. Lehan?
Aye.
Mr. Dang?
Aye.
Mr. Al-Nasif?
Aye.
And Mr. Anderson?
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Ms. Shepherd, the board staff will be in communication with you with an agreement in a few days after the meeting. Thank you for being here with us today.
All right, thank you.
Best of luck in your continued recovery.
Thank you. You'll have a great one.
Thank you.
Bye-bye.
25J, complaint number 24-0192, Sally Wilton.
I am recused.
Thank you. Ms. Mitchell, do you want to give us a summary? Is Ms. Walton present? If you could please sit down and turn on the mic and introduce yourself.
Sally Wilton.
Ms. Mitchell?
On March 26, 2024, the board received a notice from the Department of Public Safety indicating that Sally Welton's fingerprint clearance card had been suspended. The notice stated that Ms. Welton had been arrested and/or fingerprinted for misdemeanor shoplifting. After receiving the notice, staff searched the internet for charges matching those referenced in the notice from DPS. The Maricopa County Justice Court website indicated that Ms. Welton had been charged with shoplifting removal of goods on or about March 20th, 2024. Staff allowed Ms. Welton 10 working days to notify the board of her charge, and she did not do so. In her response to this complaint, Ms. Welton stated that she had been apprehended at Walmart on March 19th, 2024. She stated that she was not aware that she was required to report her charge to the board as she did not apply for a technician job. Ms. Welton told staff that she no longer needed her registration as she did not wish to work in the pharmacy.
Ms. Walton, would you like to add anything before we proceed with questions?
Just that I stopped trading in there before any of this even happened, so that's why I didn't report. I didn't think it was relevant, so I did not wish to go further in training at that point.
So are you saying that you don't want to hold a license anymore?
No. Well, yes, that is what I'm saying.
Okay. Would you be willing to voluntarily surrender your license?
Yes.
I'd like to make a motion for a consent agreement for voluntary surrender. If not signed within 30 days, refer to hearing.
Second.
I have a motion and a second. Dr. Gandhi.
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan's recused, Mr. Dang, Mr. Al Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Madam
Thank
Chair.
you, Ms. Walton, for being here. The board staff will be in communication with you.
Thank you very much.
Appreciate you being here. 29E and 29F, I think we can take together. They are two deviation requests for Avenir Behavioral Health. Welcome. If you could please introduce yourself. If you could turn on your microphone, please. Thank you.
I'm Richard Fisher, Director of Pharmacy at Avenir Behavioral Health Center.
Thank you. Board members, I believe both of these are renewals. Is that correct, Mr. Fisher?
Yes.
I'm not sure who the compliance officer is here, but do our compliance officers have any concern with the way the pharmacy is currently operating? Oh, here comes
Yeah.
Rom.
Rom was here.
Ah, now we're just missing Nancy. How am I going to call Nancy up today?
Next time.
Okay.
Good afternoon, board members. This is Ram Kalapudi, Compliance Officer with the Board of Pharmacy. I have inspected Avenir Health and there were no concerns. Yeah.
I think we already talked about this. If there's
Yeah.
no change in
Nice.
operation, then I would say to approve both requests for deviation.
I do have one question. That you're asking for 33 hours a week, saying that that's best suited for that pharmacy. I'm just curious, how is that best suited to not have a pharmacist there 40 hours a week?
Well, it's a small 32-bed hospital. We have automated dispensing machines. And I'm on call and my weekend pharmacist is on call 24 hours. And live about a mile from the hospital. So I'm able to resource whatever they need, whenever they need it.
So just curious, you don't work 40 hours a week as the director.
No.
Okay.
But the pharmacy open every day, but total of 33 hours
Right.
a week, right?
I'm there from 7 in the morning till noon.
Yeah.
And then we have remote access to review any
Okay.
kind of orders or anything they may need to have us look at. And if it's something pertinent that I need to attend to, I usually go right down to the hospital.
Okay. So there is no day without pharmacy open.
Exactly.
Okay. So I make motion to approve for both. And I don't know if they need to come every 2 years or 1 year anymore. We discussed that yesterday, right? There will be like, unless there is a change.
We
in
can
the
discuss that and at the future meeting agenda and add that for a future discussion.
I like that.
Madam Chair, the concerns that I have here, is it is a 32 beds facility and he's requesting 33 hours per week. We have to take into consideration of the patient census too. It fluctuates. Their winter season, high census, summer season, low census. I feel that we should try to maintain 40 hours per week for patient safety. But I just don't want to set a precedent for small hospitals moving forward will have less than 40 hours of pharmacist coverage during the day.
I do have my regional director on link. If he could answer to where the 40 hours versus 33.
I don't know that we need that. I mean, Dr. Granda, we have a number of these already in place across the state, right? Like I can think of at least probably 10 or 15 we've approved over the years since I've been a board member.
Agreed.
I don't think this is setting a precedent.
And it's not new. This isn't new to us. We're just renewing what's already been in place.
I see like Dr. Tang points that we don't want this gonna be a norm that when owner, like business owner, would take advantage of this cases to lower the cost, and that at the end will affect our patient safety. So we're not talking about this case in like.
But our inspector also testified that he doesn't have concerns about the safety of the pharmacy. So I feel personally comfortable in continuing. It is my personal opinion.
Madam Chair, I'd like to just make a comment and support Dr. Dang's comment because, you know, when we do deviation requests, there is supposed to be an expected public benefit. And not having pharmacists is not an improved benefit to the public, you know, and how is it furthering the mission and technology advancement? It's not meeting those deviation request standards, in my opinion. Well, it's still a deviation. And I understand census, the small location. You have critical access hospitals with 25 beds that have a pharmacy open 40 hours a week. So it's certainly doable. And I think the deviation request is not necessarily aligned with our mission to improve the safety of Arizonans. I just wanted that on the record. I think we have had precedent, but I don't see that it's benefiting the public to have a pharmacy open less than 40 hours a week, supporting a 32-bed hospital.
Yeah. Another thing I want to add on is, let's say if this hospital is located up north in the rural area, I'm fine with it, but it's right in Surprise, which I don't see any problem for your facility to find a part-time pharmacist or even PRN pharmacist. So for the square footage, I'm perfectly fine with that. But the 33 hours per week for short term, I'm okay. But consistently year to year, you coming to us asking for 33 hours per week coverage, I think you're abusing it because you should not have any problem finding pharmacists here in the Phoenix area.
I agree with that. I mean, for temporary, like for sure is okay,
Yes.
but moving forward, like, you know, for a long term, I believe 40 hours is the right thing for our people.
Right, that's what's in the rules, 40
Yes.
hours.
So you're a behavioral health facility, correct? Are you giving IV or anything like that to patients? No, so it's pretty much oral medications for that. Okay.
And unless, I don't know if work remotely, that will consider providing service to the pharmacy, to hospital.
40 hours a week is like the average American's work week. I don't think that there was some magic number that went into the rules that said 40 hours is, you know, the perfect amount of hours for a pharmacy to be open per week. If they've determined as a business that 33 hours is sufficient to meet their patient needs, seems to me, and there's been no safety issues, and this is a continuation, seems to me that we should allow that to continue.
But it is in the rules, right?
But we are also talking about removing it from the rules. So, I mean, I think we need to think, like, I don't know how long this rule has been in place. We do not change rules as fast as pharmacy practice is changing. And we're looking to try and become less prescriptive because the environment continues to change in healthcare. This is a different type of a hospital than an acute care setting, in my opinion. Now, granted, I'm not the hospital expert on the board, but I don't know. Just because it is a rule doesn't mean that I think it's necessarily, like, should it be a rule, I guess is my question.
Yeah,
If we've got a bunch of
deviations,
deviations, should we have a rule?
Madam Chair, I personally think 33 hours is fine as long as they're on call, as I've stated, 24/7, and that they're nearby. And I think if we do this, we should recite why we're making that exception in this case.
So you mentioned that you work, you are on call, right? 24/7, and you have another pharmacist can help, right? When you take days off. So, and this is brought before when we had deviation request about opening 2-3 days a week only, which is I'm totally wasn't fine with that. But at this time, in this case, I feel like believe it's been working with them and 33 hours, but I agree, like we need to discuss if this is something we can accept like always, or we have to set up to the rules. But for now, I keep my motion to approve.
Did we have a second?
I'll second.
I have a motion and a second to approve both the deviations. Any further discussion? Do we want to do a voice vote or do we want to?
Should we separate them? So that one is the square footage and one is the hour request?
I think we should separate them because they're two different special requests on the
So-
agenda.
Okay, so the hours. We'll do that one first. So do we have a motion to approve the hours?
I'll make a motion to approve the hours.
Do I have a second?
I'll second.
Yes, we do. Okay, so do we rescind the original motion?
Can you rescind?
I rescind my motion.
But, okay, do we rescind the second? Okay,
To rescind. Less.
less.
I rescind.
Okay, so do we have a motion for the hours?
I did. I said.
Okay. Okay. Do we want to do a voice vote? Or a roll call?
We'll do a roll call, Madam Chair.
Okay.
So you mentioned hours, just to be clear, this is 29F, correct?
Yes.
Mr. Braswell.
Aye.
Mr. Thorwald.
Aye.
Ms. Nair.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Lehan.
Aye.
Mr. Dang.
Hey,
Mr. Al Nassif.
Nay.
And Mr. Anderson.
Nay.
Ayes have it, Madam Chair, with 3 nays.
Thank you, Dr. Gandhi. And on the square footage request,
I move to approve the deviation on the square footage request.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Mr. Fisher, for being present. Thank you, Ron. That takes us to 29G. Discussion, consideration and possible action regarding Taylor Roberts' request to take the Naplex for the 5th time. Hi, if you could please introduce yourself for the record.
Taylor Roberts.
Hi, Ms. Roberts. Can you please tell us why you're here today?
Yes, I'm here to request the board on their consideration for me taking the Naplex for the 5th time.
And what are you doing differently this time to prepare?
So the biggest hurdle that I had was I was a caretaker for my parents and they are now on the up and up. They both survived cancer. So, and now that they are taken care of, I've been able to just focus on studying. I took out a personal loan to help pay for the U World RX prep and book. And so I've just been studying for that and using those resources.
Board members, any additional questions?
Looks like you got your intern license in September 2018 and it's now lapsed. Just
Yes.
Curious, did you graduate in 2018?
Yeah, no, 2022 was when I graduated and I started pharmacy school in 2018.
Okay, thank you.
I move to approve. I'm sorry.
Have a motion and a second. All those in favor?
Aye.
Any opposed?
Just a comment, Madam Chair. This is the 5th attempt and in this state it's the last attempt.
I was just going to say the same thing. You beat me to it. You understand, Ms. Taylor?
Yes, ma'am.
Best of luck. I'm sorry, Roberts. Best of luck to you. I'm glad to hear your parents are doing well. And
Thank you. Thank you all so much for having me before you. It means a lot. Thank you.
and
Thank you so much.
thank you. Next up, 29H, Rebecca Green requests to take the MPJE for the 5th time.
She is online, Madam Chair.
Ms.
Yes, I'm
Green, if you
here.
could please introduce yourself.
This is Rebecca.
If you could please tell us a little bit about why you're here today.
So my situation is actually similar to the person before me. I became primary caretaker for both of my parents who one is disabled and then one my mom, she has a rare hereditary disease and was in a clinical trial for the past year. And so with that and going, not only that, but I was going through like legal relationship matters and also had a case of kind of like like stalking harassment case going on. So it just with everything, it was very difficult for me to kind of, I guess, focus on studying. But now that most of everything has been resolved, my parents will be moving in with my sister for her to take care of them. I believe I should have a better chance of studying properly and focusing on my exam.
And what are you doing differently to prepare?
Well, to be honest, with my sister taking care of my parents, that will take off a huge load. I stepped away from work so that I could focus more on the exam, and I will also be utilizing the MPJE like UWorld study prep that they have.
Board members, any additional questions?
I'll make a motion to approve.
Do I have a second?
Second.
All those in favor?
Aye.
Any opposed? Hearing none, best of luck to you, Ms. Green. Same speech as before. You understand that this will be your last attempt to be able to pass the MPJE in Arizona.
Yes,
correct?
I do. Yes, thank you.
Best of luck to you.
Thank you.
29I. Manmet Kaur, request to attempt to take the Naplex for the 5th time.
Hello.
Hi, if you could please introduce yourself and tell us why you're here today.
Hi, my name is Manmeet Kaur, and I'm here to ask if I could take my Naplex for the 5th time.
If you could please tell us what you're doing differently to prepare for this attempt.
This time I got a private tutor and I signed up for another online courses. I borrowed some money from my family, and I'm also going to be taking help from my previous preceptor that I worked with, and I'll be focusing more on like the clinical aspect of it. And during previous attempts, I wasn't aware that I had anxiety and ADHD issues. I also started seeing a psychiatric doctor, so I'm on medications now so that I can focus more during the exams. And I'm seeking a private tutor, like I mentioned before. So yes, hopefully that all can help me this time. So that's all.
Have you looked at seeking an accommodation for the exam?
Yes, I have, and they approved me recently.
Okay. Additional questions?
Make a motion to approve.
Second.
We have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Best of luck to you, Ms. Kaur. Again, this will be your last attempt that we're allowed to approve for you in Arizona, so very good luck to you.
Thank you so much. I appreciate your guys' time.
Thank you. 29J, Shira Maneshthrakar. Hi, welcome. If you could please introduce yourself and tell us why you're here today.
Hi, thank you. My name is Shreya Thakara, and I'm here to petition to take my MPJE for the 5th time.
What are you doing differently?
So I actually have a statement. It's short.
Yeah,
Sorry.
go ahead.
Thank you. So I have always been struggling with exams throughout my education into pharmacy school and onwards, and I've been very hard and dedicated myself to my education. I've had a lot of mentors and supports over the years to help me pass my board exams, and I'm currently working in an independent compounding pharmacy to use my knowledge and skills to prepare for my board exams. Despite my efforts to pass both NAPLEX and MPJE, I did take a much needed break to focus on my mental health in July of 2023 after failing both MPJE and NAPLEX. I was diagnosed with ADHD and working.
You don't have to mention your health conditions on the record.
But I've been working closely with a mental health professional and have been able to come up with a focus or create a study plan with a focus for the NAPLEX, and I was able to pass my NAPLEX on the 4th try. So I'm working with the mental health professional again to try and, or we've created a study plan for my MPJE after using materials and purchasing materials from the Pronto Pass Solutions, the UWorld, and other pharmacy law question banks, as well as the MPJE competencies from the NEBP, the Arizona Law Book, and other federal law books. So I've been mimicking testing questions or mimicking testing settings for my practice questions so that I'd be able to prepare myself for the MPJE. So I am humbly requesting if I could take my MPJE for the 5th time.
Thank you. Board members, any questions?
Make a motion to approve.
I second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, best of luck to you.
Thank you.
Again, this is your last attempt that we can approve for you. So good luck.
I understand. Thank you.
That takes us to item 31, items for future meeting agenda items. So I heard from Dr. Gandhi that we will add, I think, 2 things. We'll bring back the pending item report that Ms. Snare mentioned yesterday and look at potentially agendizing how we want to handle timeframes on deviations. Is there anything else anybody wants to add?
I do. We're all jumping at it.
Go.
So a couple of things. One, in our non-disciplinary grid that we work from, we don't have anything for closing without notifying the board. And it's come up multiple times in this meeting. And I don't know if it's appropriate to be there, to be honest, or we would consider that disciplinary. But it's just something to discuss. And I've brought this up before, but I think that the idea of someone coming before us to ask if they can take the MPJE for the 5th time is something we should do away with. And we look at deviations to see if there's, no purpose for it. And I feel like that practice should be looked at again. I don't see any purpose for it. We've always approved it. Definitely people are aware that's their last attempt. I only see it as kind of a public shaming. So that's my personal opinion, and I'd love to discuss that again.
Just to piggyback on that, that was exactly what I had in mind. In my opinion, I feel that all these pharmacist interns have already gone through so many stress in their life, for failing so many exams. So having them appear in front of the board to me, is unnecessary. I think we should delegate the task to the board staff. Dr. Gandhi can make the decision.
So we can we can put this on a future agenda instead of having a discussion.
Sure.
Thank you.
Yeah, I think it's a good idea. Anything else?
Sorry. I'd like to make one comment. If you need anybody else on the Rules Committee, since I do not make any participate when it comes before the GERC, I would like to be involved in that if possible.
Thank you, Mr. Thorwald. Anything else?
That's plenty, Madam Chair.
Well, now that you have a new executive assistant, we got to make sure that, she keeps you in line, so I hope you're taking good notes,
I
Anna.
guess my last comment, we have discussed previously about billing OTC, like talking about contraception, but we have not made any decision yet, right? About
I think, well, maybe an update on that at the next meeting.
Have it down.
All right, cool. Let's do call to the public. Roger left again. Roger, are you online? We're waiting to hear from you.
I should just call him.
we miss it. What? We don't know.
He said on a break that he had something for us.
I will not hear this here. That's the wrong way. I don't want to hear it.
Mr. Morris, we were waiting for you.
Hi, I wanted to actually test how long it took to get in from the public. So I called in instantly as it came up. So just to give you an idea. Apologize for running out, but I had a personal thing to deal with. My quick one is just very simple. I wanted to remind everybody again that the American Society for Pharmacy Law is having its annual conference in Phoenix.
Roger's cutting out.
On November 8th. Yeah, I apologize. November 8th through the 11th. I was getting some backlash from I still had the screen up with it. And I wanted to just recommend to anyone who's listening or any of the board members or compliance officers, it's a really good conference. It gives you a lot of issues that are going on around the country. And I believe Dr. Gandhi is one of the speakers, so that will also be fun to see. That's it.
That should draw a large crowd.
It is actually a really good meeting.
No, definitely.
Like
No, I agree.
one of my favorite conferences, actually. Thank you, Roger.
You're welcome. Thanks, guys.
Madam Chair, I think that's all we have online.
We will